Good morning, everyone. We're now calling the February 1st, 2022 Cobb County Planning Commission meeting to order. First order of business, we don't have anyone for our prayer this morning, but if we could all stand, do a moment of silence, and then go right into our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Our first order of business, I'm going to throw it over to our county attorney to address some rules for the Planning Commission.
Good morning, members of the Planning Commission. I'm going to read in a motion to allow for virtual participation, and then I will encourage someone to move and second that and take a vote on that. Since the county is under a declaration of emergency regarding COVID restrictions, part of that emergency declaration authorizes this Planning Commission to allow for virtual participation by the citizens at the Planning Commission public hearings. The Planning Commission must approve of this before the virtual participation is allowed today. The current declaration of emergency expires on February 20th, 2022. In the event the declaration of emergency is extended another 30 days, it is recommended that the Planning Commission continue to authorize virtual participation via the following changes to the Planning Commission Rules of Procedure. 1, staff and citizens be allowed to participate in the meeting virtually. 2, Planning Commission members can vote by voice or by hand signal if necessary. 3, persons wishing to be counted as either in favor or in opposition to an application be recognized. The number of persons will be provided to the Planning Commission. 4, persons who wish to speak virtually in favor or in opposition to an application will identify themselves accordingly to the Information Services technical staff or other staff for participation during the presentation of the application. 5, persons who speak virtually will acknowledge and affirm that this is his or her testimony before the Planning Commission is under oath or affirmed to be truthful. Otherwise, all Planning Commission zoning hearing procedures will apply.
Thank you. We've heard the rules. Can I get a motion to approve that?
Motion to approve.
And a second?
Second.
Second by Commissioner Anderson. Let's call the question. And that's approved by a vote of 5-0. Thank you. With that, we will go ahead and get started on what looks like a pretty full day. So I will turn it over to the staff and John Peterson.
And thank you, Mr. Chairman. Today's hearing will be conducted with the following process and procedure. Each case will be called in numerical order. When each case is called, we would ask that the applicant please stand and raise their hand so they can be counted for the record. Then after that, we're going to call to see if anyone here is opposed to that case. We would also ask that the opposition please stand up and raise your hand so they can be counted for the record. After recognizing both parties, they will be asked to come forward to be sworn in so they can present testimony to the board. The applicant will testify first, and then the opposition, if any, would testify second. It's important to note that each side gets 10 minutes to state their case and concerns. There's not a rebuttal process, and there's not a process to reserve your time, so you need to convey all your information to the board within your 10-minute time period. Additionally, if more than one person wishes to speak on a case, you may want to coordinate with each other about what you're going to talk about, because each side only gets 10 minutes, and you don't want to cover the same information twice. Then after that, the board will start to discuss the case at hand. From the discussion from the board, they may ask one or more people to come back to the front for questions or comments. And then after that, the board will make a decision to either approve, deny, hold, or continue the matter at hand. There are 4 cases on today's printed agenda which have been withdrawn without prejudice, and these cases will not be heard today. First case withdrawn without prejudice is rezoning case Z68 of 2021, Tiffany Gray. This case has been withdrawn without prejudice and will not be heard today. Second case is rezoning case Z88 of 2021, Taylor Morrison of Georgia, LLC. This case was withdrawn without prejudice and will not be heard today. Third case is rezoning case Z10 of 2022, Drayton, LLC. This case has been withdrawn without prejudice and will not be heard today. And the last case on the printed agenda is SLEP2 of 2022, Campus Realty Advisors, LLC. This case has been withdrawn without prejudice and will not be heard today. Mr. Chairman of the board, we did get a request late last week to withdraw 2 other cases. That's rezoning case Z61 and SLUP 7 of 2021 for Blue Tiger Properties, LLC. So at this point, we would ask the Planning Commission to withdraw Z61 and SLUP 7 without prejudice.
So is that, could you repeat that, Z1 and Z7, right?
Z61 and SLUP 7.
Z61 and SLUP 7. Okay, that is in District 1, so Commissioner Boulogne, I'll turn that over to you.
Thank you, Mr. Chairman. Move to allow the withdrawal of those applications without prejudice.
Do I have a second?
Second?
A seconded by Commissioner Dance. Call the question. Any discussion on that? Not, let's call the question. Okay, that's approved by a vote of 5-0.
Thank you. Next on the agenda are continued or held cases that will not be heard today. First case is rezoning case Z1 of 2022, Pulte Home Company. This case was continued by the staff until the March 1st, 2022 Planning Commission zoning hearing, so Z1 will not be heard today. Next case is rezoning case Z7 of 2022, KM Homes. This case was continued by the staff until the March 1st, 2022 Planning Commission zoning hearing, so Z7 of 2022 will not be heard today. I would like to ask people in today's audience, if you have a cell phone, please turn the volume off on your cell phones. When the phones ring, they do interfere with the broadcast and presentations. Any person wishing to speak before the Board of Commissioners must file a campaign contribution disclosure statement. If within 2 years immediately preceding the filing of a rezoning application, a campaign contribution totaling $250 more was made to a current member of the Board of Commissioners. Additional information about this requirement is located on the table in the back of the room. And I want to remind applicants, opposition, and any interested party that information is due to this board the Wednesday prior to this hearing. Any information submitted to this board after the Wednesday due date may or may not be considered by the board at their discretion. Mr. Chairman, Board, I do have one request for an early head count. Can I get a show of people here who are opposed to rezoning case Z9 of 2022, Winsong Properties? Please stand up and raise your hands.
You got 12?
12. Let the record show there's 12 people here opposed to rezoning case Z9 of 2022. Can I also get a show of people here who are in support of rezoning case Z9? Please stand up and raise your hands.
We have nobody.
Let the record show there's no one here in support. I would like to remind the folks
John, can I interrupt to ask a question?
sure thing.
Are there any online or virtually for that same question?
There are 2 people virtually who are opposed to rezoning case Z9.
Okay, thank you.
And I would like to remind the folks who have to leave after the early head count, they do need to leave 1 or 2 people here to make their points when the case is called. And Mr. Chairman, Board, before we get going, I do want to announce that the staff will remove rezoning case Z4 of 2022, Quentin Wiggles, and rezoning case Z9 of 2022, Winsong Properties from the consent agenda. And we're just going to put those in the regular order of business today, later down in the agenda. So we will not read Z4 or Z9 into the consent agenda. And with that, Mr. Chairman and Board, I'm ready to start the consent agenda. Cobb County Planning Commission zoning hearing consent agenda for February 1st, 2022. First case on consent is rezoning case Z3. Eldemira Alas requests a rezoning from LI to R20 for a single-family residence in land lots 868 and 909 of the 19th District. The property is located on the south side of Powder Springs Road, west of Flint Hill Road, Pine Grove Drive. Staff recommends approval, subject to the following conditions. Number 1, Cobb DOT comments recommendations. Number 2, stormwater management comments. And number 3, water and sewer comments. Is there anyone here opposed to rezoning case Z3?
We have 1.
Let the record show there's 1 person opposed. So we'll go ahead and pull that one off consent agenda, Mr. Chairman and Board, and put it in its regular order. Oh, okay, that's the owner. Okay, Mr. Chairman, Board, I'm going to correct that. The person who stood up was the owner, not the opposition, so that one will stay on consent. Rezoning case Z6, VG Developers request a rezoning from GC to OS for an office and warehouse in land lot 84 of the 16th District. The property is located on the northeast side of Shalford Road, south of Jamerson Road. Staff recommends deletion to NRC with a special exception, subject to the following conditions. Number one, revised site plan received by the zoning division on January 7th, 2021, with the district commissioner approved minor modifications. Number two, district commissioner approved final building architecture and landscape plan. Number three, special exception allowed for a contractor's office who is a builder for this applicant and use only. Number four, applicant to ensure the proposed plan does not exceed 70% impervious coverage. Number five, fire department comments and recommendations. Number six, stormwater management division comments and recommendations. Number seven, water and sewer division comments and recommendations. And number eight, Department of Transportation comments and recommendations. Is there anyone here opposed to rezoning case Z6? One person? Okay. So we'll take Z6 off consent, Mr. Chairman, Board, put it into regular order. Rezoning case Z12, Cameo Capital LLC, request rezoning from CRC to LI for office, warehouse, showroom, light industrial in land lot 861 of the 19th District. The property is located on the east side of Tremor Point Parkway, south of the east-west connector. Staff recommends approval, subject to the following conditions. Number one, letter of agreeable conditions from Mr. Kevin Moore dated January 26, 2022. Number two, site plan last revised December 15, 2021, with the district commissioner approving minor modifications. Number three, fire department comments and recommendations. Number four, water and sewer division comments and recommendations. Number five, stormwater management division comments and recommendations. And number six, Department of Transportation comments and recommendations. Is there anyone here opposed to rezoning case Z12?
No.
Let the record show there's no one opposed. And moving into land use permits on the consent agenda, LUP 1, Karen Gooden, request a temporary land use permit for a hair salon in land lots 622 and 637 of the 19th District. The property is located at the terminus of Foxcroft Court, east of Valley Brook Drive. Staff recommends approval for 24 months, subject to the following conditions. Number one, hours of operation to be from 10 a.m. to 7 p.m., Monday, Thursday, and Friday only. Number two, all parking to be on a hardened surface and not in the right-of-way. Number three, applicant to be the only employee, no independent contractors. And number four, staff comments, recommendations not otherwise in conflict. Is there anyone here opposed to LUP 1?
No.
Let the record show there's no one opposed. LUP 2, Stephanie Soliers request a temporary land use permit for online soap sales in land lot 208 of the 16th District. The property is located on the east side of Farmbrook Lane, north of Farmbrook Trail. Staff recommends approval for 24 months, subject to the following conditions. Number one, no signs. Number two, no on-street parking. And number three, no outdoor storage. Is there anyone here opposed to LUP 2?
No.
Let the record show there's no one opposed. LUP 3, Early Education LLC, requests a temporary land use permit for a daycare in land lots 50, 51, 94, and 95 of the 17th District. Property is located on the west side of Hurt Road, north of Plantation Road. Staff recommends approval for 24 months, subject to the following condition. The maximum number of students permitted by the state and fire codes. Is there anyone here opposed to LUP 3?
No.
Let the record show there's no one opposed. LUP 4, Joyful Living PCH requests a temporary land use permit for a personal care home in land lot 50 of the 17th District. The property is located on the north side of Hurt Road, east of Fred Walker Drive. Staff recommends approval for 24 months, subject to the following conditions. Number one, maximum of 6 residents. Number two, no parking on the right-of-way. Number three, all stipulations from previous land use permits also apply. Is there anyone here opposed to LUP 4?
No.
Let the record show there's no one opposed. And finally, LUP 6, Dathan J. Johnson requests a temporary land use permit for a pet dealer in land lots 769 and 770 of the 19th District. The property is located on the east side of Shady Side Road, north of Hurt Road. Staff recommends approval for 24 months, subject to the following conditions. Number one, maximum of 1 customer per week on site. Number 2, maximum of 15 dogs on the property. Number 3, Cobb DOT comments and recommendations. Number 4, maximum of 3 litters per year. And number 5, Stormwater Management Division comments and recommendations. Is there anyone here opposed to LUP 6?
No.
Let the record show there's no one opposed. And that completes the consent agenda, Mr. Chairman, with Z4, Z6, and Z9 off the consent agenda.
Thank you, Mr. Peterson. So with the removal of those 3 cases, can I get a motion to approve the consent agenda as revised?
Motion to approve as revised.
Do I have a second?
Second.
Second by Commissioner Anderson. Any discussion on the consent agenda? None, I'll call the question. It's approved by a vote of 5-0 for the consent agenda. Thank you.
Okay, all those folks that were on consent, you're free to go. Just come back in 2 weeks for the Board of Commissioners zoning hearing. Moving into the continued or held cases to be heard. Mr. Chairman and Board, the first case also has a companion special land use permit. Would be the board's wishes to hear these cases together and then make separate motions on both?
You have general consent to take the SLUP and the case together?
Okay,
Awesome.
thank you. Okay, rezoning case Z48 of 2021, Ray Murphy. Ray Murphy requests rezoning from GC to LI for a towing and automotive record service in land lots 154 and 155 of the 17th District. The property is located on the northwest side of Austell Road at the terminus of Austell Circle, along with its companion special land use permit case number 3 of 2021. Ray Murphy requests a special land use permit for a towing and automotive record service in land lots 154 and 155 of the 17th District. The property is located on the northwest side of Austell Road at the terminus of Austell Circle. The applicant is present. Is there anyone here opposed to Z48 or SLEP 3?
No.
Let the record show there's no one opposed. Would the applicant please come forward to be sworn in? And while the applicant's being sworn in, Mr. Chairman and Board, we do have a representative here from Code Enforcement if you have any questions about it.
Good morning. My name's Vicki Murphy Norris. I'm representing my dad, Ray Murphy, with applications Z48 2021 and SLUP 3 2021. I'm here to present some good information with progress we've made with code enforcement in regards to rezoning to the LI from GC. The rezoning is a result of many code violations and losing our grandfather clause. Business has been there since 1986. We have made major improvements. The record and towing service has more steps involved as far as removing things from the property legally than I actually knew about in the beginning. The property has been cleaned. We have pictures. Thank God for code enforcement meeting me at the property. I have a new respect for them and appreciation for that entire department. They have really done much more than anyone else would have probably done without me begging for help. They have a presentation that shows from the very onset of our endeavor here to last Friday. We did meet at the property on a regular basis. They have drone video that I had asked for, requested, and Cobb County did pull through with that. Very thankful for the drone in the beginning and on Friday afternoon. I have not seen those drone videos yet. I did see pictures that Yolisa and Kathy Pickett did send to me that showed great progress. And initially, yes, the property was in disarray with code violations, and I actually did not know the extent of the violations until we had the drone and the additional pictures from code enforcement. Working with the tenant, we have discovered, yes, we've cleaned the property up. However, there are many, over 100, maybe 130 vehicles sitting on the magistrate's desk that has not been signed off for us to move those the vehicles to their proper places. You have to go through a certain method of reporting, how you report it to the police department, you report to certain aspects. You go to the magistrate's office, they sign off, or they hold for different reasons. I'm not sure. I'd have to get with the tenant on reasons. Tenant and magistrate has been working hand in hand since we started. Kathy Pickett was so gracious to show me and help me go to the magistrate's website and figure out we did have a massive amount of vehicles sitting there. During COVID, I think we only had one judge signing off on those particular things from wrecker and towing services in Cobb County. So we are working towards that with getting additional cars out off of the magistrate's desk and back into the system to get them off the lot, which would be auctioning the cars if the owners are not found and magistrate signs off on it's an abandoned vehicle. So that was one big step that was in the puzzle that I didn't know about as far as all the cars that were located on the lot. There were several cars that were antique cars, been there for years, and was requested to get those particular cars off the lot. We did. And we have pictures, which is awesome. Very proud of code enforcement for helping me on that. I do have information regarding some of the things that we need to work on as far as moving forward with the application. We had mentioned last visit the buffer area that we need to establish around the property and certain things that we need to move forward with as far as the application. The primary concern was code enforcement initially. Now we have pushed through the majority of that, and we are working towards the application for the LI from GC. There will be no changes in the business operations at all, so I'm hoping that pushing towards this LI is not going to be as complicated as your normal light industrial zoning. We're only rezoning because of the code enforcement and the loss of the grandfather clause. We did pull up certain things online. We analyzed, the tenant and I analyzed some of the things that are in the staff comments recommended for denial. And of course, recommendation for denial is something that I want to turn around for an approval. I do not know if the staff, your planning staff is awesome in regards to helping navigate these things with documented papers. The things that I'm not sure that can take place are, can the planning staff revise that packet to help me implement an approval, whether it be some stipulations, whether it be a variance? I'm not real sure how the process goes with those particular steps. The special land use permit, I believe, is for the heavy equipment on the lot, but I'm not really sure exactly what the special land use permit allows for us to do, because we're not changing anything in our business. It's been the same business since 1986. So I did send an email again that no one replied to. I called Jenny, and she, graciously, said that she'd go ahead and reply to that one and document pictures that had been sent. There is a question on the zoning packet that says we are surrounded by residential, and it would not be good for that area to keep our business there due to heavy residential. I did go onto certain websites for nearby properties, and I didn't have time to make copies, but if you want to look at some of the nearby properties, they are commercial. The only residential that we have that I can pinpoint is an apartment complex that's been there right behind our property, to the side and to the back of the property for many, many years. Have no opposition, no complaints from them thus far since 1986, as far as I know. But there's 3 or 4 pages of that show you the nearby areas that are not residential. The apartments, they are. This came off of your website, which shows, I'm hoping it's legible, it shows the different categories that surround us. And the R20, of course, I think is the apartments, I'm not positive. My question is, I want to be sure that we're pursuing code enforcement like we have been, and continue to do what they need for us to do to proceed with the application for the light industrial, even though we're not changing any aspects.
You have 1 minute left.
We're not changing any aspects of the property. The LI rezoning is simply for Cobb County code and ordinances with what they need in regards to our business operations that have not been changed since 1986. And I'll be glad to answer questions or give, information that I might not have covered if you need to ask any more questions.
Thank you.
Thank you
Thank you.
for your consideration and all your help. I appreciate it.
Thank you. It's my understanding there was no opposition for this case. Okay. With that, I'm going to turn it over. This is in District 1, so Commissioner Ballorn, I'll turn it over to you for the discussion.
Okay, thank you, Mr. Chair. John, who do we have here from Code Enforcement?
We have Ms. Yolissa Folsom from Code Enforcement.
Okay, if she could come forward.
Good morning.
Good morning. Can I get you to state your full name again?
My name is Yolissa Faustin, and I'm the senior officer at Code Enforcement.
Okay, thank you. Can you give me an idea of whether we've had very many complaints about noise on this property? Has that been a basis of any complaints, to your knowledge?
To my knowledge, I have not received any complaints in regards to noise at the property.
Okay. Any complaints about light or brightness or lights at night or things of that nature?
No, sir.
Okay. Any specific complaints about any environmental issues?
No, sir.
Okay. So it's possible this is something we could work through if we get all the necessary buy-in from the applicant. Is that your read, or do you think?
Yes, sir. We definitely can.
Okay. I heard something about you folks going out and taking some pictures, or
Yes, sir.
do you have any of those with you today?
I do.
That'd be great.
So I started inspecting the property around November 10th, 2021. When I went onto the property, there was a significant amount of violations, but since then, there has been a significant amount of progress too that the code enforcement is satisfied with. So this is the drone footage from November 10th when the fire marshal came out to look at the property to give an aerial of what the property looks like. Am I supposed to double click this one twice? Okay. Thank you. Okay, so that was pretty much an overview of the property. During my inspection on November 10th, Mr. Murphy, who is the owner of the property, had 15 of his own personal vehicles that was in junk condition stored at the property. And there was also tires, debris, and a lot of junk around the property. There was a old bus there with a tub on top of it. And also there was weeds that was about 2 to 3 feet high. And pretty much a lot of these vehicles, some of them had dates from 2019, 2018, 19, and 20 because of, there was about 130 cases when we looked into it that was pending with the courts. So between COVID and the courthouse shutting down, and then also during that time frame, they had a new system, which it changed from the way they filed to get title to these vehicles. That stopped the process, but their new secretary was trained on how to file the paperwork correctly, and since then they have been moving forward with correcting the filing of the documents and moving these vehicles off the property. I went back on November 22nd to inspect the property again, and Alberta, who's the owner of the business, brought in a dumpster and started removing all the junk off of the property. On 11/29, I came back, and the large pile of tires that we seen in November 10th, was removed along with debris, and Mr. Murphy's vehicle started to be removed from the property. On 12/26, when I returned, the old bus and the tub that was there was removed, along with the weeds being cut down and a lot of debris. And there were also some vehicles that were removed from the property. I went back on November 13th and noticed that the property was getting a lot cleaner to the point where you can move vehicles on and off the property without any issues. There was 7 out of 15 of Mr. Murphy's vehicles that was removed, and progress continued at the property, and the property looked a lot cleaner. I went back to the property for a final inspection before today on Thursday or Friday, January 28th. That was Friday. And 54 vehicles had been removed from the property. for the month of January, and that included the last 8 of Mr. Murphy's vehicle. As of today, there are 179 vehicles at the property. And this is just the drone footage that shows that the property is much cleaner from when the fire marshal came out on January 28th.
What are we looking at here? Are we looking at wrecked cars? Are these cars drivable? You know?
Some of the vehicles are wrecked and some of them are operable. It's just that the owner of the vehicles have not picked them up, and then also the cases are still pending with the court.
You indicated during your presentation so far that you, and I might be interrupting your presentation, if so, I apologize, but you indicated that you had seen progress in terms of forms being filled out correctly to move things through the courts and get permission to remove cars. Mm-hmm. Is there anything where we need to follow up with any of the judges, find out if anything is not being done right, or is this something where you think the process is moving properly now?
The process is now moving properly. We did have an issue before, but their secretary did receive the appropriate training, and now the vehicles are moving. I know when I spoke to the owner about, it could have been a week or two ago, he did have 20 cases pending with the court to be signed off on one day.
So are most of your code enforcement cases you have a result of them having lost their grandfathering, or is it something else?
It's a lot of different reasoning, but once you alter a property and change its use, then you would lose, your property would no longer be under the grandfather clause because you altered it.
Okay, what are we looking at here in terms of the parking lot outside of the fence? This is the apartment complex or a commercial property?
That's an apartment complex that's right behind, well, it's right next to the towing lot.
Have there been discussions with the property owner about trying to go to a situation where they add, I think we've talked about this publicly, add some greenscaping there to mitigate the views?
There has been some discussion about making some alterations at the property, and they were going to speak with the arborist about what's allowed and if they have a buffer or not to make some changes.
Okay. Do you have more to the presentation?
No, sir.
I don't want to interrupt. Okay.
Oh, no, this was just the ending, just to show you guys that there has been a significant amount of changes. They cleaned up, they removed some vehicles, and the property looks a lot cleaner, and we definitely are satisfied with the progress that is being made in the effort.
Okay. Perhaps some of the other members of the Planning Commission have questions for you.
Other questions from other commissioners?
I had a question, Mrs. Foster. One of the things that I wanted to see last time was an actual parking plan, just showing how much is the capacity within this. Is there any requirement to have actual spaces noted or marked that exists in place today? Because if not, that's still something where it feels like there'd be, I would love to see a little bit more of an organized understanding of what can be parked where and how much is the actual capacity that we're going to say is the max for this site. Is there anything in place right now that says you can pack up to X number of vehicles, or there's certain areas that you can't park? And I don't know if that's a code enforcement thing, but I'm just, if to your knowledge, is there anything that relates to that?
With this property being grandfathered and losing that clause, I am honestly not sure, and I will get you an answer. The thing about it is I know if it is approved, there'll be stipulations as far as parking and everything, but normally when we have a property, it normally has to have lined paved parking, and they can't park on like the grass, gravel, or dirt. But with this property being grandfathered before then, I would have to check with my manager and also zoning to see what exactly is allowed as far as parking and the amount of vehicles and everything.
Thank you. And
Thank you.
Just to confirm, you said there are now 179 vehicles on the property?
Yes, sir. There's 179 vehicles as of January 28th, 2022.
Okay, excellent. Thank you very much.
Thank you.
Other questions? Not, turn it back up to you.
Yes, just briefly, what number of cars do you think could be on here and still provide an adequate, safe 20-foot greenscape buffer? Do you have any idea there if there's a number of cars we should move towards restricting this to, or is that something we could maybe do some deciphering on over the
I
next 30 days?
think that would be something for you guys to decide. I honestly,
Okay.
that's not my expertise right there as far as many vehicles as he could have. I mean, right now with the 179, he has room to move vehicles around comfortably. So if he added a few more, that would be fine, but he still would be able to move it around, but he doesn't want to have it to where he cannot move at all.
Okay, but my concern is more to require him to stop parking cars in an area within a certain distance of the fence line and to require some additional greenscape buffering if we're going to pursue this path. Is that feasible, or is that not feasible for his business?
It is feasible, because right now, the vehicles are parked up on, I guess, the property line, because of where the fence is at, they're backed up onto that property line.
Okay, so are you comfortable with proceeding on a path to try to cooperate with the applicant if we can get a parking plan as requested by Commissioner Anderson, and if we can get a landscaping plan as I would like? Is that something that you think would be reasonable accommodation to allow this use to continue, yet to protect the adjoining property owners?
Yes, sir.
Is there anything else I should add to that?
No, sir.
Okay. Thank you. Thank you for your excellent report. And it's nice to hear applicants come up here and say nice things about county employees. So congratulations on that.
Thank you. Y'all have a good day.
Okay, you can do it online. Yeah.
Okay.
That's
Mr. Peterson,
okay.
is there anything else we need to have at this time, or is this something where we can ask the applicant to come back with some additional detail? Is there anything else we should include in that, or any other concerns we should address today before making some requests of the applicant? Yes?
Oh,
Is there-
okay.
Do you have any thoughts on this?
Yeah, what I have in my notes so far is a parking plan per Commissioner Anderson, a landscape plan per Commissioner Boulogne. And one thing you may want to also look at is if they choose to put in parking lot lights or a lighting plan, that be approved by Department of Transportation and Community Development. I'm not sure if there's plans to do it or not, but just so the lights don't bleed onto the apartment property behind it.
Okay. Okay, do any of my fellow planning commissioners have any comments, things that they think I should get addressed here at this time?
Just one. The applicant stated that she had some additional questions and some understanding around SLUP. So is it staff's intention to meet again with the applicant to help walk her through some of her additional questions?
Yes.
Okay.
One more question, John. How much time do you think we should set on this to bring this back?
Commissioner Boulogne and board, I'll feel comfortable giving her another 90 days because, she's made a lot of progress in the last 90 days.
Okay.
And, since this is not a result of a complaint from an adjacent neighbor, I think we should give her some more time. So I'll be comfortable giving her till May 3rd, 2022 to come back with parking plan, landscape plan, lighting plan, if any, and then to show more progress on the property.
Okay. Well, thank you all very much. I'm ready to proceed with the motion unless.
Just a question.
Yes.
With respect to that 90 days, is it reasonable to get progress updates during that 90-day period?
Yeah.
Yes. Who do you think we should have them made to? I know you have a lot of experience at community development.
I would think staff would want it, at least
Yeah,
progress
and the
updates.
applicant has a really good relationship with our code enforcement division. So, what we can do is have them meet every couple of weeks, and then at your work sessions coming up for March and April, we can give you updates at that point in time.
That'd be great. Thank you.
All right, so that recommendation was for meetings between code enforcement and the applicant, or
Correct.
at least every 2 weeks
Yeah.
to maintain progress? Okay. Good. All right, in that case, my motion would be that we continue this case for 90 days. We continue both cases for 90 days, including the SLUP, to provide the applicant sufficient time to work with community development and planning staff as needed to put together a parking plan, a landscape plan, and a lighting plan. And the stipulation on this is that the applicant meet at least once every 2 weeks with code enforcement to continue to make progress and show progress toward achieving these goals.
Before I ask for a second on that, I'm going to turn it back to Commissioner Boulogne to see if we can amend your motion to hold it instead of
Yes, that's
continue.
fine, that's fine. My apologies, hold, that's fine.
Okay. Do I have a second?
Second.
Second by Commissioner Anderson. Any discussion? If not, let's call the question. It's confirmed by a vote of 5-0 to hold Z48 and SLUP 7 for 90 days to be heard on May 3rd. We need to do a separate. We need a separate motion for the SLUP. I'm sorry.
Okay. Identical motion to hold the SLUP for a period of 90 days based on the same conditions.
Do I have a second?
Second.
Second by Commissioner Hughes. Any discussion? Let's call the question. Confirmed by a vote of 5-0 to also hold SLUP 3 till May 3rd with those stipulations. Thank you.
Thank you. Okay, next case on the agenda is rezoning case Z80 of 2021. Timothy G. Jenkins requests rezoning from GC to R20 for a single-family residence in land lot 142 of the 20th District. The property is located on the north side of New Rutledge Road, west of Meadowlark Lane. Is there anyone here opposed to rezoning case Z80?
No.
Let the record show there's no one opposed. And is the applicant online? Okay, the applicant was trying to get online to present his case virtually, so he's not on yet?
No, they're having problems scheduling, so
Okay,
I don't know if they can work it out or not. Or he can be here in 20 if they're
okay. The applicant is trying to work through getting on the link, so what we're going to do is just kind of put this case on hold right now and come back to it later on in the meeting. So we're just going to move on to our next case, Z83. Case, rezoning case Z83 of 2021, St. Burke requests a rezoning from OS to RM8 for a townhome community in land lots 390 and 391 of the 18th District. The property is located on the north side of Mapleton Parkway, northwest of Honeycutt Road. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to rezoning case Z83?
No.
Mr. Chairman of the Board, there's no one here in person opposed to this case, but there are two people who are virtually opposed to rezoning case Z83. So at this point, I'll ask the applicant to come forward to be sworn in to present his part of the hearing.
Appreciate it. Thank you for your time today. My name is Dan Mason with St. Burke. I'm here on behalf of Curley Family Homes for case Z83. Our current zoning is OS, and we are asking for an RM8 zoning. We also have 2 lots which are off of Rio Circle, which are currently zoned RM12, which we are not rezoning, but we are including one of the lots as open space as part of the development. We have been working with the Mapleton Coalition and comments from staff since December, and have come up, I think, with a pretty good plan here that I think is something we can move forward with, hopefully. As I said, it's OS, and we're going to RM8. So some of the things we've done, we're following the current comprehensive plan, getting our unit density down to 5 units per acre, which is what the comp plan allows for. We're asking for 38 townhomes on 7.5 acres. Our pricing will start in the low 300s, and sizes will be starting at around 2,000 square feet. That puts us at an overall density of 5.06 units per acre. All the units will be for sale units, and we will limit the amount of rentals to only 4 rental properties in the development. There will be front and rear alley loaded product. And since we only have 1 entry and we have 38 units, we are going to sprinkle all of the units. And there'll be a central lawn area with pavilion, and there'll be a separate dog park area. There'll be a mandatory HOA, which will be responsible for all community maintenance. The grounds will be professionally landscaped and maintained. All units will have a 2-car garage, and the garages, written with a condition into the HOA guidelines, is that garages must be used for parking and cannot be used for storage. That will help with our parking situation. We will have a minimum of 23 feet from the back of sidewalk to the front of garage so the sidewalks will not be blocked. And we'll have sidewalks on both sides of the road and underground utilities. We'll work with the county school system to determine the best spot for a bus pickup for the residents' children, and do a standard what they require, or a little arbor bench area or something for the students to sit at while they wait for the bus. We'll also have follow the Mapleton guidelines on landscaping and sidewalk along our frontage and our facades. And we've agreed with the coalition to allow them to have a look and review of our landscape plan prior to when we get final approval from the county. So this is our updated plan. As you can see, we have a private alley off to the right, which allows units to face onto Mapleton Parkway. And then the other units face onto an open space, our park area. And then we have a turnaround suitable for fire at the end of the alley, and as well at the cul-de-sac towards the north. Here's a little closer look at the plan itself. So you can see that, a better look at what we're proposing there. Our dog park will be down to the north of the property, kind of away from the residents, so if there's any noise from that, it's kind of isolated up against the power line and in the woods, and protected to the north with more open space. So some of the things we did with the just from December, I'll just go through that kind of real quick of what the change was. We started with 59 total units, and now we're at 38. We deleted, we had a townhome entry. You can see the previous plan to the left here. We had a townhome entry on Rio Circle, and we had some townhomes on those existing single-family lots. And so we've deleted that now, and we removed that, and we're proposing that lot number 2. It is kind of a low area with a pipe on the road, but we're proposing that to be open space, or if required, when we get into engineering, if we need to retain some water there could be a small detention area there if required. But we will not build on it or do any type of, vertical building on it, other than a possible small detention area if required. We also shifted the road to the west to push those units further away from the homes along Rio Circle. And that was one other thing we did. And one of the bigger things, the coalition was, one of their requests was they did not want private roads. So we're now proposing public roads. And I'll speak about that in a second here. But that's one thing we've changed as well. And then we've previously had units backing up to Mableton Parkway, and now we have units facing the road. So you'll see the front of units, and we'll landscape that area and from the parkway to where the units start to have a nicer look from the parkway. And we've also added the dog park, and we've created a larger lawn gathering green space area for the residents to walk and get their mail at kind of that cul-de-sac area to the north. So we are asking for a couple of variances, and it's mainly the front yard setback. We're asking for 15 feet, and what that does is it helps kind of push those units to the north, further away from the houses that they're backing up to on Rio Circle, and it just helps push the whole development a little west from Rio Circle. And it also helps with some topography on those northern units. We're also asking for a 10-foot side, again, 20 feet between buildings. With our units being sprinklered, that shouldn't be an issue. 20 feet is usually standard. And then we're asking for a 15-foot side corner, and those lots would just be for those two on the alley. As soon as you drive in, those two facing the alley that face the parkway and face the park, those side corners would be 15 feet off the right-of-way. Another thing we didn't get to, as far as we were required for 38 units, our driveways are about 17 feet wide, so that requires us one space per unit, which is 38 is total required. We've gotten to 27 units on our plan, and that does include a couple to the right over there, a couple units a couple spaces for parking off of the private drive. And all the other units within the right-of-way are parallel as required. Here's some of the elevations of what the townhomes will look like. They're a mixture of brick, stone, and hardy plank with covered front porches, covered front stoops. And so that's some other ones that they look like. These are, of course, the front-loaded alley ones. I mean, front-loaded ones, not the alley product. The alley product will not have garages on the front. They'll be on the back, obviously. So that's all I have for the presentation today. I appreciate your guys' time, and if you have any questions, I'm here to answer them. So thank you.
Okay. You left a balance of 1 minute and 34 seconds, just in case any opposition goes over. So are the two folks for opposition virtually, are they prepared to speak now?
Our first virtual citizen is Mary Rose Barnes. I'll tell you when she's unmuted. Mary Rose, you've been unmuted. You can speak now.
Yes. I'm here.
Go ahead.
I'm Mary Rose Barnes. I'm representing 3 homeowners who live along the adjacent Ryoka Circle. I join with them in opposition to C-83. When your board granted a hold to St. Borg, it was our expectation that the applicant would come up with a site plan that properly depicted the actual property to be rezoned and to provide stipulations that would include a definitive description of the proposed product. Instead, even after 2 months' time, the latest site plan, prepared only yesterday, still depicts an adjacent tract of RM12 zoned RM zone property, lot number 2 on Ryoka Circle, not a part of the property. I have to say that today the applicant said that the property was 7.5 acres. The site plan says the property is 7.1 acres. According to the site plan's development standards, this lot number 2 is to be open space or detention if necessary. Detention for the property, the project, or the site itself, we don't know. If the applicant should wish to include lot number 2 in a development of this property, he should withdraw the application and submit another application at a later date. The site plan as presented itself would be unworkable in any future iteration, as it does not include the requisite mail kiosk. St. Board's stipulation letter is woefully lacking in detail. There's no mention of the number of units, the tract size, or that it actually would be condominium ownership, the square footage of the units, number of bedrooms, signage, fencing, if any, street lights, mail kiosks, screening of the fencing of detention facilities, etc. The list of HOA responsibility does not include the private streets, and without just receiving that new site plan, it appears that the alleyways are still private. There's no mention of responsibilities for a dog park, pavilion, detention ponds, etc. There was no mention of any accommodations for neighbors in the event of necessity of blasting, even though blasting is now ongoing in the immediate area. My residents' homes are now being having damage or possible damage to their homes, and this Ryoka Circle is directly adjacent, closer than the location of blasting going on now. Development of this site should be compatible with the neighborhood and designed by professionals who understand and follow the precepts of county standards and are willing to share relevant and crucial information readily. On behalf of Mr. Tim Newsom, Ms. Lois Gilbert, and Mr. Hans Cornfield of Ryoka Circle, I respectfully request that you recommend denial of this 83 application. Thank you.
All right, thank you. Do you have a second?
Our next speaker is Robin Meyer. Robin, you are unmuted.
Good morning. My name is Robin Meyer, and I chair the zoning committee for the Mableton Improvement Coalition. I fully agree with the points raised by the previous speaker, Ms. Barnes, and ask that you once again hold this application until a complete plan can be reviewed by your staff and by the community, along with a full and complete stipulations letter, neither of which, the plan and the stipulations letter, neither of which we received until last night from the applicant. We did see the stipulations letter online previously, and Mr. Hughes was kind enough to share a site plan over the weekend. But once again, this does not meet the spirit of working with the community. We contacted Mr. Mason periodically since the December 7th hearing, but we did not have any response from him about this information until last night. We're not opposed to townhomes at this location. We think it's a good use, but there are just too many things still hanging and still uncertain. First of all, public streets. These are not public streets. These are public streets and private streets. We do not support the parking variance. If there's an overflow of cars to be parked in this community, there are no adjacent side streets or neighborhoods that they can even overflow into. It'll simply mean that the streets are blocked. The plan lacks sidewalks, mail kiosk, and a notation as to where the variances actually are. There are quite a few variances proposed in this presentation, but there's simply no time been available for the staff to analyze whether or not the applicant's representation of those variances is correct. The stip letter is woefully lacking. There's no minimum square footage in it. The elevations are missing from it. And we have yet to see elevations of the units that now face Mableton Parkway. So the elevations that were previously shown will not be the ones that we see from the street. The buffer question hasn't been answered. We still don't understand from the applicant what is in that buffer now. Is there presently year-round visual screening that should be left undisturbed, or should it be replanted with evergreens? That's a question that needs to be asked and answered prior to approval of this application. I wish to underscore that the Rioka Circle lots cannot be included in promises made by the applicant associated with this application because they are not included in this application. There's nothing to prevent the applicant from disposing of those 2 parcels to someone else, having a home built on them, having some other use made of them, because any decision made by you or the Board of Commissioners based on this current application will not apply to those 2 lots on Rioka Circle because they are not included in the application. Probably the most important issue here is that your professional staff has not had time to look at the site plan. DOT, fire, zoning, we simply don't know how this plan stacks up against the county ordinances. These are a basic list of questions that we discussed with Mr. Mason from the start many months ago, and still these questions remain in the air. So we ask that you hold this application and require that St. Burke return with a full plan and a complete stipulations letter. However, if you wish to move this application forward today, we would ask that you recommend denial. Thank you.
Thank you. That's it for opposition? Okay. Seeing that this case is again in it's in zone 4, I'll turn it over to Commissioner Hughes.
Thank you, Chairman Vaught. If I could have the applicant return. Good morning, Mr. Mason.
Good morning.
And thank you for, we exchanged some emails over the weekend, updated site plan, and I think late last week you sent me a copy of your proposed zoning stipulations. I think you've heard some concerns here this morning from a couple of Mick as well as Mary Rose Barnes. Can you address some of these things?
She's correct. I didn't want to. The OS portion of the property is 7.1 acres, and so that density is 3.5. But once we include that lot number 2, which is 0.4 acres, that gets us to the 7.5 acres, which is basically the 5.06 density.
But that's not part of the application, though, correct?
Correct, because it already had a higher zoning, so at the time, we just didn't include it because, previously we'd showed townhomes there, but we just removed them.
But I guess, not to interrupt you, but you indicated at least that you may, if detention is required, you would put detention on lot 2, correct?
If needed, because it's already like a low area. I don't think it's a buildable lot because there's the sewer you can't get to because it's low and there's already a pipe there that goes under the ground. So, I mean, we're happy to do some type of stipulation where we agree to make that permanent open space or,
I guess I understand you saying it's RM12.
It is RM12.
But may not be buildable, but you still don't want to include it in the zoning application, I guess.
Well, I'm fine. Yes, we're fine to include it as part of the property and make it open space.
Okay. And then I think there were some questions too with respect to the internal streets. I know we went from private along the main street.
Yes, well.
And then your site plan just submitted to me over the weekend still it shows a public street, but then there's a private alley. So.
Well, that's just, since those are rear alley loaded product, that's a 30-foot easement with a private alley. I just assumed the county did not maintain alleyways. I could be wrong.
And that's probably a question for DOT.
Yeah. So we called that private. It also, I think with being private, it allows us to get a little more parking in there with the 90-degree, which I know the county doesn't want to maintain 90-degree parking, so it's another reason to make it private. And, you know, alleyways are just usually private. So that's why we made it private.
Okay. And then the question about the buffer along the, I guess, the eastern property boundary backing up to the lots along Rioka Circle. Do you know what sort of plantings are in there now?
It's just a mixture of, I believe, pines and hardwoods. It's just, you know, woods probably never been cleared for, you know, no telling how long. So it's just wooded. It's just wooded at the moment.
And this, I believe this property is at a higher elevation
It is. It
than
does
the
sit
property,
higher.
than the lots that are along Rioka Circle. That's correct?
Yes, sir.
Okay.
And I'm sorry. We are showing sidewalks now on both sides of the road, and we do have the mail kiosk showing to the north. So we have added that. You know, as far as, you know, we're happy to have, you know, a planting along between the homes. You know, if it's required, I just didn't think they'd want us to go in there and clear a natural buffer.
And I don't think they're suggesting that.
Yeah.
I think what they're suggesting is that we do an inventory of what's there, and then we make a determination of what's best
Yeah.
for the adjoining property owners.
Yeah.
There may be some evergreens in there that may be worth preserving. Maybe the county arborist can visit the site to really
Correct.
take a look at what's there.
Yes.
And make a determination of what would be in the best interest of
Yeah.
both properties.
Yeah.
What are the dimensions of the units themselves?
They're 22 wide, and I don't know the exact depth off the top of my head. They're somewhere around 55 or 50 feet deep at least. But they're 22-foot wide units.
Okay. I guess here's where I'm going with this. I think the site plan still needs some work. And typically, on a project like this, you would zone it to a specific site plan where the details are extremely important to note, because that's going to be the public document going forward that you would, those are the standards you'd be held to. So I'm a little concerned we still don't have answers to some questions, and I do think it's important for our professional staff to have an opportunity to look at the site plan, to weigh in professionally,
Yeah.
as well as the community. But let me stop there and see if my fellow commissioners have any other questions, and then I have questions of staff, professional staff.
Any other questions from other commissioners? Commissioner Dan.
I heard the question raised, and I have the same question. What is the plan for guest parking on this? Can you tell us conceptually what that is?
So it's, can we go, is this the? It would be parallel along the public right-of-way, and then there's a few spaces we added. If you go to that, no, keep one more. Sorry. One more. I don't know if you can see this, it's parallel along the road, and then there's some off the alley for those units parking as well. Like I said, we're at 27, which is 0.7, basically, and the code requires 1 unit. So we're shy of that.
So clarify what you just said. The code requires how many parking for guests?
One parking space per unit.
And what do you have?
We have 0.7, so it requires 38, we have 27. But we also have the code in our HOA, which we work with the coalition, asked for, that, you know, requires the garages to be kept open for parking, and, you know, 2 spaces allowable in the parking space. So each unit could, in theory, park 4. So.
My perception is that it looks inadequate, and I think, you know, to the extent that you're moving forward, that's certainly one area that you would want to address.
The parking?
Other questions? Commissioner Anderson?
Yeah, and this might be kind of a tag team question with staff and yourself, but in terms of the design guidelines for Mapleton Parkway, the frontage guidelines, I believe, for the architecture are for buildings with over 100 feet. Is that correct, or is that your understanding?
That's what yes.
Okay. So I think just as a kind of thing to see on the next plan, just would love to understand kind of, since I don't think the articulation of the actual facades are really in any of the elevations are kind of covered under those guidelines. Would love to see some language around what kind of articulation of the actual facades are being kind of contemplated for the actual building fronts, particularly those that will now be facing the parkway. And then I think the second kind of element, which again, just as a point of input on the design guidelines, would be in terms of the staircases on the plans. I've seen a couple of the Curly Home plans before where there tend to be metal staircases with open areas below springers, which kind of create a very repetitive look. Stringers, sorry. But if there's any opportunity to kind of have a more aesthetically appealing landscaped or covered area along the front entryways that covers that area below the staircases, I think that could just be an element that would allow for more, combined with the articulation of the facades, a more, I guess, a more nuanced and suitable look. I only say these because I don't believe they are guidelines that are captured under the framework of the design guidelines that's currently spoken. So those are just things that would be helpful to see in future iterations on the elevations in particular.
Okay, sure.
Commissioner Balloon.
Thank you, Mr. Chairman. And again, John, just for planning purposes going forward, it sounds like the applicant's going to need to go back to the drawing board a little bit. Based upon what I've heard, there's a suggestion that additional lands need to be brought into this plan, and if so, can we go ahead and amend the application to do that? And if so, how soon could we hear it again?
Based on what I heard today, he needs to address parking, landscaping, elevations, including the RM12 into the application, detention. It's definitely an application that can be revised, and I would feel comfortable not holding it for 30 days, but holding it for 60 days, so staff would have enough time to do a good review on it.
And that revision process can specifically include the submission of additional land to the...
Correct.
Okay, thank you.
I'll turn it back over to you, Commissioner Hughes.
Thank you. Is anyone on the line from DOT? Just a quick question.
Amy
This is
Diaz?
Diaz from DOT.
Hey, Amy. Just a quick question regarding DOT's policy for maintaining private alleyways, or is there a policy as it relates to private alleyways?
The applicant is correct. We would not maintain the private alleyways. The most limited access that we maintain is the local roadway, which is the 50-foot right-of-way, and no perpendicular parking, and no hammerheads. That's the other thing that would require those alleys to be private, is they have hammerhead turnarounds.
Okay. And I just want to confirm, your team hasn't had a chance to weigh in on this revised site plan at this point, correct?
We have not. Looking at the plan on what they presented today, I believe what it's indicating is that the public roadway would be just the north section of the road, the main drag up to that cul-de-sac, and then both of the alleyways that go from the cul-de-sac and from the main area would be private. That needs to be clearly marked on the plan, but I would have to. There's some design details of the kind of cul-de-sac they're showing, which is called a bubble cul-de-sac. I have to run those by traffic operations. And I also have to do some measurements to make sure that they wouldn't lose that front parking space as you approach Mableton Parkway because it may be too close. So there are things that we certainly want to check on this site plan beyond, them getting fire's approval and the private versus public as far as the commission is concerned.
Okay. All right. Thank you very much. I appreciate that. Anybody have any questions of DOT? Okay. I think based on what I'm hearing today, what I've heard from the applicant, what I've heard from the community, I'm prepared to offer up a motion that we hold this application for a period of 60 days to give the applicant a time to revise the site plan based on feedback that he has received here today. And that is my motion.
We have a motion on the table. Is there a second?
Second.
Second by Commissioner Dance. Any discussion? Let's call the question.
Thank you.
Let's confirm for a vote of 5-0.
Thank you. And that hearing date in April is April the 5th. So I would ask the applicant to please update my planners with the revisions they make so we can change the ad properly for it. Mr. Chairman of the board, I do have a little bit of good news. The one case we pulled off V6 on the consent agenda, the person who stood up to oppose it was actually the applicant, so they misunderstood what we were doing at that point in time. So if it's okay with the board, we can add Z6 back to consent agenda. If it's okay with the board, I'll read it back in and call for opposition again.
Okay, so Z6, let me just state this, there's no opposition now to Z6, correct?
The person who stood up was the applicant.
Okay. I know that was on Z3 as well, so Z6, I was just.
Same
okay.
thing happened.
Got it.
Right.
So with that, do I have a motion to add Z6?
Mr. Chairman, let me go ahead and read it in first, and then we can make the motion to add it back
Go
to
ahead.
consent. Okay, rezoning case Z6, VG Developers request rezoning from GC to OS for an office warehouse in land lot 84, the 16th district. The property is located on the northeast side of Shalford Road, south of Jamerson Road. Staff recommends deletion to NRC with a special exception subject to the following conditions. Number one, revised site plan received by the zoning division on January 7th, 2021, with the district commissioner approving minor modifications. Number two, district commissioner approved the final building architecture and landscape plan. Number three, special exception allowed for a contractor's office, which is a builder, for this applicant and use only. Number four, applicant to ensure the proposed plan does not exceed 70% impervious coverage. Number five, fire department comments and recommendations. Number six, stormwater management division comments and recommendations. Number seven, water and sewer division comments and recommendations. And number eight, Department of Transportation comments and recommendations. Is there anyone here opposed to rezoning case Z6? Let the record show there's no one opposed.
Thank you. So now I will entertain a motion to approve the revised consent agenda with the addition of Z6.
So moved.
Second.
Second by Commissioner Hughes. Any discussion? If not, let's call the question. Okay, the revised consent agenda with the addition of Z6 is confirmed by a vote of 5-0.
Okay, and we're still waiting on Z80 to link in, so we're going to move past that again.
Can move to regular cases and come back
Yes.
to Z80.
And the next case, Z2 actually has a special land use permit with it. Would it be the board's wish to hear both cases together and make separate motions on both?
That requires general consent, so I'll look if there's anyone opposed to combining the case and slip.
Okay.
Okay.
All right, rezoning case Z2, Pat Spencer, U-Haul Company of Atlanta West, request rezoning from CRC and R20 to CRC for a self-storage, truck and trailer rental and retail in land lots 789 and 790 of the 19th district. The property is located on the west side of Ernest Barrett Parkway, on the south and east sides of Laura Brown Way. Together with the special land use permit number one, Pat Spencer, U-Haul Company of Atlanta West, requests a special land use permit for a storage, truck and trailer rental, retail in land lot 789 and 790 of the 19th district. The property is located on the west side of Ernest Barrett Parkway, on the south and the east side of Laura Brown Way. Is the applicant present? Yes. Let the record show the applicant is here. Is there anyone here opposed to these two cases?
No.
Let the record show there's no one opposed to the rezoning or the special land use permit. And there's no one virtually, right? There's no one virtually. Would the applicant please come forward to be sworn in?
Good morning. My name is Jeff Bellier. I'm with CHA Consulting. I'm here with Pat Spencer, the applicant. He is with U-Haul. We are here to request the property to be rezoned to CRC, and also we're requesting a special land use permit for the self-storage unit. The property is located in front of Walmart on Barrett Parkway. When Walmart was designed many years ago, this property was master planned to be one day developed for commercial use. Utilities, access, stormwater management are all included for this property. Okay. Yes, thank you. Just trying to get to the site plan real quick. Okay, I don't see it in there.
That's the present. Separate file.
Okay. Okay. Thank you. Okay. As I said, the access was master planned for this. We are both driveways, as you can see. Is there a pointer on this? Yeah. Both driveways are internal. No access or direct access off of Vernon Barrett Parkway. We've read the staff recommendations, and we're willing to comply with those in terms of right in, right out, and left out access for this driveway closest to Ernest Barrett Parkway. The development has two buildings. The larger building is roughly 117,000 square feet, it's 3 stories. This will be the climate-controlled storage building. And then the smaller building, which is roughly 7,000 square feet, will be for the storage pods. No variances are requested. The area that you see in green is the green space that we're providing. Any questions we can answer, we'll be happy to do so.
Does that conclude your presentation?
Anything you want to add?
We can go through the presentation to see some elevations, but there's nothing specific to this site yet, but some of the things that we've done throughout the country. So you could see those if you wish.
I'm fine if that's the balance of your presentation. I'm going to turn this one over to District 4, so Commissioner Hughes.
Thank you, Chairman Vaught. I would, if I know maybe it sounds like you haven't developed specific elevations yet for this.
Correct.
Do you have, as part of your presentation, just a sample of what it might look like?
Okay, these are a couple, Commissioner Hughes, that we've done. This one was done in Levine, Arizona. And a lot of what U-Haul does is we do a lot of reuse as well, but this would be a ground up. This one was done in Lake Wiley, South Carolina. This is what the building actually looks like today.
Okay.
Libertyville, Illinois. This is one was done in Phoenix. And then Elk Grove, California. Fort Lauderdale, Florida, Houston, Texas, and those are just a few of them, but we've done quite a bit throughout the country.
Okay.
Sorry.
What generally are your hours of operations for for this type of facility?
7 to 7, Monday through Saturday, 9 to 5 on Sunday.
And then your clients have 24-hour access
Yes,
to
sir.
the property?
Yes, sir.
What provisions are made for security? You have cameras on site? You have,
Absolutely, and they'll have a swipe-in, swipe-out card that they have to do it, otherwise the alarm will go off and the police will come. So they have to have that access granted first.
is there gate access to actually get in after hours? Okay.
No.
No. Okay.
Just it's all electronic.
Okay. Any other of my fellow commissioners have questions of the applicant? Okay. Thank you. I've got a question for DOT, just real quick.
Amy Diaz, DOT.
Hey, Amy, just a question. I know in your DOT's staff report, y'all recommended a traffic study. Can you just kind of summarize where you guys are with a traffic study at this point? I think that applicant provided trip generation numbers, but what?
Yes.
Go.
So, go ahead.
No, go ahead. You're fine.
Okay, so what they provided, again, yes, was trip generation information, which is about 80% of a submittal one. However, since there don't seem to be any traffic issues being raised, we're willing to accept the trip generation in this case.
Okay. All right. Thank you. Are there any other questions?
I did want to point out, though, that, that the adjustment to the driveway has not happened, so that driveway is going to be limited, no left in. And just, that's an important comment on ours.
Okay.
We understand
It's
that.
too close to the,
Okay. Yeah, the applicant is
close to
acknowledged.
the signalizer section.
Okay, the applicant's acknowledging here in person that they understand that that needs to be moved, and they'll make accommodations to do that.
We would prefer to leave the driveway where it is, but we will restrict left-in
Okay.
access.
Okay, thank you. Are there any questions of Amy Diaz, DOT? Questions of other staff?
Any other commissioners have questions regarding this case for DOT or planning staff? No.
Okay, thank you. With that, I note that the staff has recommended approval subject to the following conditions. And just quickly want to review those. Final site plan and building architecture will be approved by the district commissioner. A 20-foot landscape buffer along Ernest Bear Parkway to be approved by the district commissioner. Any work to automobiles related to installing hitches must be done inside the building. Fire department comments and recommendations, stormwater management division comments and recommendations, water and sewer comments and recommendations, and Department of DOT comments and recommendations. So I'm putting forward a motion to approve Z2-2022 and SLUP 1. And I would also ask the commission to consider moving this to consent for the Board of Commissioners.
Okay, let me just check can we take all of those as one, or do we need to do separate motions for each? Separate, okay.
I will amend that to recommend approval of Z2-2022.
Okay, we have a motion for approval of, or to recommend Z2 of 2022. Do I have a second?
Second.
It's been seconded by Commissioner Anderson. Any discussion? Let's call the question. That's been confirmed for Z2 of 2022 by a vote of 5-0. Turn it back to you, Commissioner Hughes.
Move to approve SLUP 1-2022.
We have a motion for a recommendation of approval of SLUP 1 of 2022. Do I have a second?
I think staff has a question.
Subject to the 7 conditions in the SLUP 1 staff recommendation?
Correct.
Okay.
Sorry. That approval is subject to staff's recommendations.
And non-consent also?
And
non-consent also?
And to place that on consent as well.
We can do those together. Okay. And to be placed on consent.
Correct.
We have that motion on the table. Do I have a second with the amended motion?
Second.
Seconded by Commissioner Anderson. Any discussion? Let's call the question. So approved by a vote of 5-0 for recommended approval of SLUP 1 of 2022 with recommended stipulations, as well as moving both to consent agenda. Thank you. With that, I think it's time for a break. And so we'll take a break and adjourn for 5 minutes. Thanks. All right, welcome back. And I'll turn it back to you, Mr. Peterson.
Thank you. And the applicant is online now for Z80, so I'm going to recall that case. Rezoning case Z80 of 2021, Timothy G. Jenkins, request rezoning from GC to R20 for a single-family residence in land lot 142 of the 20th District. The property is located on the north side of New Rutledge Road, west of Meadowlark Lane. Is there anyone here opposed to rezoning case Z80?
No.
Let the record show there's no one opposed, either virtually or online. And the applicant is available virtually, Mr. Chairman. So at this point, I'll turn it over to Jeannie.
Tim Jenkins?
Tim?
I'm sorry. I thought you said Jeannie. How you guys doing today?
Good.
Yes, sir. What's going on here is a house actually had burned down a few years ago. I'm just building a house back where one used to be. And then, we found out through the chain of events that the property had been zoned light commercial. So we're just in the process of just getting this flipped back to residential so we can move on.
Okay. Anything else you want to share with us, Mr. Jenkins?
Well, I've been living in a house for, 32 years now. And I was the first one built on that side of the property. And I'm just, trying to still understand how it was zone light commercial. And I don't know what it might have taken place to be able to get the permits for the houses. I guess that's my only, question is, what took place to lead us to where we are now? I guess is what I'm trying to find out.
Okay. Well, thank you. I'm gonna, this is in District 1, so I'll turn it over to Commissioner Boulogne to lead the discussion.
Thank you again, Mr. Chairman. John, would staff or ComDev have any comments as to just a general background explanation of how we got where we are?
Based on the research I've done, Commissioner Boulogne, the property has always been zone general commercial. I'm not sure how a subdivision was actually built there in, 30 years ago. So I'm going to say, because all the people who are involved with this are now deceased or gone, it was probably a mistake on the county's part.
What's staff's recommendation?
To approve it.
Okay. Subject to all staff comments?
Correct.
Anything else we need to do here or cover?
It'd be nice to put this one on consent also.
Okay. All right, I'll see if I can get the motion right. Does anyone else have any questions of the applicant or of staff? Okay, so the motion will be to approve, or to recommend approval, rather, of rezoning request Z80, subject to all staff comments with a request that the matter be placed on the consent agenda.
Second.
It's been moved and seconded by Commissioner Dance. Is there any discussion? If not, let's call the question. Okay, by a vote of 5-0, we recommend approval of Z80.
All right, thank you.
Thank you, Mr. Jenkins.
Thank you. Thank you very much. Now, I've got one more question, guys. I apologize for today. I appreciate y'all accommodating me. The second meeting is on the 15th. Do you need me to come to that meeting or log in virtually, or what needs to take place here?
It could be in person or virtual.
I think I'd like to just come down there and make sure in person this time, just see how it all works.
All right, thank you.
No, thank you, guys. I appreciate that.
Thank you so much, Mr. Jenkins. All right, back to you, Mr. Peterson.
Okay, next case we're going to hear is rezoning case Z4, Quentin Wiggles. Request rezoning from GC to R20 for 2 single-family residences in land lot 108 of the 17th District. The property is located on the north side of Ridge Avenue, east of Old Gordon Road. The applicant is present, and online there is one person virtually opposed. Is there anyone here in person opposed to rezoning case Z4? Let the record show there's no one here in person, but we do have one person virtually. Would the applicant please come forward to be sworn in?
Hello.
Good morning. Go ahead.
Oh no, the house was,
Could you state your name?
I'm sorry,
for the
I'm
record?
Quentin Wiggles.
Okay, thank you.
The house was, I knocked the house down, so I was gonna rebuild it back. It was on GC, just returned it back to Z4. I mean, it was on it to Z4.
Okay,
Oh, what
anything?
else you need, what else I need to say?
It just, anything else you want to present on this as your case?
No, I just got a picture of a copy of the survey I had done to see how I want to redo it back. You wanna see it?
Are we going to show that visual? Okay, thanks. If you want to just kind of walk us through that, would be great.
Okay. Basically, the first house, the house is right here. So I had the survey company to draw it out so I can make 2 lots out of it. The house, it's set on 1.37 acres. So the first one would be a half acre, and the second lot would be 0.91 acres.
Okay, thank you, Mr. Wiggles. This is in District 4, so I'll turn it over to you, Commissioner Hughes, to lead the discussion.
Thank you, Chairman Vaught. Good morning, Mr. Wiggles.
How you doing?
Just looking at your site plan that's on display now and then the one that's in the book, it looks like you flipped the flag, flipped it to the other side of the...
Yeah, I had the company do it both ways.
Okay. Which way do you intend to?
That way.
The way that's on display?
Yes.
Okay. Staff is recommending approval of your application at this point.
Okay.
I'm sorry, let's step back. I think there's somebody in opposition on this. Do we want to hear from them first before I start asking? I'm sorry.
No, thank you. That's great. Thank you, Mr. Wiggles. Are you done with your presentation?
Yeah, that's pretty much it.
Okay, you can have a seat. We'll probably call you back up for questions. And do we have our opposition ready on the phone?
Yes, Robin Meyer, you are unmuted.
Thank you very much. My name is Robin Meyer, and I'm with the Mableton Improvement Coalition. First of all, I want to clarify that we are very much in favor of this zoning application, and that we do recommend approval of it, but we would suggest some more specific conditions than appeared on the staff recommendations. What Mr. Wiggles has at this point is really a survey, not a site plan. So we would ask that the site plan, when the site plan is developed, that it be approved by the district commissioner so that we can see, and she can see where the houses will be situated on the lot. That's going to make a big difference for how this appears from the street. Despite the fact that this is zone GC, as you can see from your GIS map, this is an established residential R20 developed neighborhood, which was apparently zone GC years ago for a shopping center that never happened. On the site plan, we would also like to, in addition to the location of both houses, we'd also like to see the driveways and any stormwater facilities that are going to be needed. Will there be a detention pond? Will there need to be some grading to make sure that the development doesn't cause problems for folks downstream? A member of our zoning committee has been in contact with Mr. Wiggles, and we understand that it's okay with him to plant some landscaping on each side of the house at the front of the property to buffer the newer, probably a little bit larger home from the neighbors on either side. We want to clarify that each home will have a separate driveway, that there will not be a shared driveway. The driveway for the home that is at the front of the property, adjacent to Ridge Avenue, should run from the street up to the house, but not past the side of the house. It's a nice wide lot, but there's really not room for 2 driveways to go past this house that will be adjacent to the street. We've seen Mr. Wiggles' proposed home plans. And they are in excess of 1,800 square feet, but that might be a good thing to specify as well. And we would also ask that the final elevations be approved by the district commissioner. We would encourage you to recommend approval of this application. We're happy to have new homes built in our community and wish Mr. Wiggles great success with this. Thank you.
Thank you so much, Ms. Meyer. Okay, with that, I'll turn it back to Commissioner Hughes to lead the discussion on this.
Thank you, Chairman Walt. I don't think that I have any other questions. Let me have the applicant come back up just real quick. If I could get someone to put those conditions back up from Mick, that'd be great. So, Mr. Wiggles, I just wanted to ask you, for the record, these are some recommendations from Mableton Improvement Coalition. Have you had a chance to go through these? Are you comfortable with these conditions if they were made part of your rezoning request?
Yeah, the house, the first house is going to go exactly back where the house that I tore down is going.
Okay.
Well, I have no problem with none of that.
So you understand you'd have to submit a final site plan to the district commissioner with input from the Mableton Improvement Coalition. The site plan would be presented, which are the locations of both the house, driveways, any required stormwater utilities.
Let me ask you a question. So, as of, like right here?
I can't see where you're pointing.
I'm sorry. What's that thing? Like the driveway for the property in the back is, this is actually the driveway going to the house would be right in here.
Yes, sir.
You know what I'm saying? Okay.
Yeah. So.
This is my first time. I'm just.
Oh, no, I understand. I understand. And you're doing a great job. You're doing a great job. You see the site plan presented to the district commissioner shall include a 10-foot by 50-foot evergreen landscape strip along the east, so you're fine with that?
Yeah, the tree, yes, no problem.
Okay. Each home will have a separate driveway, no shared driveways. Your
Absolutely.
driveway for the home on the southern portion of the property will run directly to that house, so you don't
Yes.
want to be, okay. And minimum square footage of 1,800 square feet.
Absolutely.
And then final elevations will be approved by the district commissioner. Okay. All right. Staff is recommending approval of the application.
Okay.
So I think you may know that already.
Yes.
Are there any other questions the commissioners have of the applicant?
Any other questions from fellow commissioners?
Or staff?
No.
Okay. With that, I'm prepared to offer a motion to recommend approval of your rezoning application Z4 with staff's recommendation and including a letter from the Mableton Improvement Coalition dated January 26, 2022. Can I, I'd like to move this to consent. So as well, I'd like you all to consider moving this to consent for the Board of Commissioners meeting as well.
Okay, we have a motion for recommended approval. Seconded by Commissioner Bellon. Any discussion? If not, let's call the question. So by a vote of 5-0, we recommend approval for Z4 as well as addition to the consent agenda. Thank you so much.
All right, thank you.
Okay, next case is rezoning case Z5, Wee Ping Schneider, America 101 LLC. Request rezoning from R20 to RD for a duplex in land lot 85 of the 16th district. The property is located on the north side of Old New Day Schoolhouse Road, west of Canton Road. Is the applicant present?
Yes, we are.
Let the record show the applicant is present. Is everyone here opposed to rezoning case Z5 in person?
No.
No. Let the record show there's no one here in person or virtually opposed to rezoning case Z5. Would the applicant please come forward to be sworn in?
Good morning, Mr. Chairman, members of the Planning Commission. My name is Bill White. I'm here on behalf of my client, Huey Snyder, as well as America 101 LLC, which are solely owned limited liability company. She owns the property at Old Noonday Schoolhouse Road, which is application Z5 2022. This is currently a residential street surrounded by the NRC zoning. If you've been out there, it's a dead-end street with 4 residential houses on the right-hand side as you pull in. Of course, one of those houses, the first one on the right, is GC, so it's not being used as a house, but it hasn't been torn down. The second building is LRC zoning, which is an office. It was converted from residential. It was actually a quadruplex back in 2019. You cited it for a zoning violation, and they converted it to LRC. I think they originally asked for apartments. That was denied. And so you deleted it down to LRC. And it was converted to an office. It's been sitting vacant since August of 2019, and it's currently for sale. If you've been on that particular street, it's somewhat of a secluded area. It's surrounded by trees. As you come up Canton Highway, you crest a hill and turn left into the street if you're going north. And so it's not a visible area. And so I imagine they're having a hard time marketing that property as offices. The next house adjacent to my client's property is residential. And then my client's house that she purchased in 2009 had already been converted to a quadruplex by the previous owner. The property was foreclosed. She bought it from a bank. This was her first ever investment property. She'd never owned one before, and she still only owns this one. And she's a long-term employee of the Postal Service. So when she bought it, if she had checked the zoning, she would have discovered that it was not permitted to be used as a quadruplex, but she didn't do that. And so that's how we find ourselves here today. She continued to operate the property as a quadruplex from 2009 up until when it was cited in 2019. At the time, she was undergoing a divorce, and there was a question as to who was going to get the property, which is why she didn't apply for the rezoning before now. So that's where we are today. Of course, the staff has recommended denial of a duplex because the future land use plan is NRC, which would mean that you would either permitted uses would be LRO or LRC. Based on the current location of the property, it's kind of unusual. It's not really a good location for LRO or LRC, although it might be a parking lot, I suppose, because it's just so secluded that it's not visible from the road. It might, I guess, suppose be a landscaping office or something of that nature, but because of where it's located, you just don't have any visibility from Canton Road. So we have requested it for rezoning as a duplex. We realize that that is not compatible with the future land use plan, but we think that's the highest and best use of the property at the present time. Because as we've mentioned, the property right down the street was zoned LRC in August of 2019, and they haven't been able to make any use of it since they rezoned it. Do you have any questions?
Okay. Is that the end of your presentation?
Yes.
We may have questions for you.
All right.
Let me turn it. Good. Let me turn it over to, this is in District 3, so Commissioner Dance to lead our discussion.
Is there any opposition?
There's none.
Okay, let me ask you, does your client live at the property?
No. It's rented to 4 people probably my age or older. One of which has recently been in the hospital and may end up going into a nursing home and will probably not be back. There's another retired person and 2 people that are still working there. And we understand that, of course, if the zoning is denied, it becomes a single-family resident. We have to evict 3 of the tenants. If the zoning was permitted, we have to evict 2 of the tenants. understand that.
How much time exists on the leases?
Actually, none of them have lease left, and they are senior. They are older people. They can really afford outside rent. So my rent is very, very low, like $500 a month, all utility included. I pay for them, $600 for 2 bedrooms. So I guess I give them very affordable rent. They've been there for a long, long time, and they don't have any renewal lease. I can just tell them, I guess, give 30 days that you have to move out.
So how long have they been there?
Many, many years, as long as I own that 2009, because all these are older people.
These individuals have been at the residence since 2009?
Yeah, 2009, 2010, it's been there for a long, long time.
Mm-hmm.
Yeah. And I don't even increase the rent because I kind of helping them as long as I can cover my mortgage, you know. So it's kind of like both way. And I put a lot of work on that place because when I first purchased, there's no street sign. I have to call the county for the street sign to put on. And there's no light there. I actually called the power company to put lights on there. I mean, the street was so broken. I have to call the DOT. I have to call the county to help to fix the street. So they don't really want to move. And when dealing with my divorce, I don't even know I still have able to own the property. I told them they may have to move because the property may have to be sold. And they were very upset because they told me there's no way they can really afford outside the rent. So I don't know. I'm here to try to make it legal, whatever way I can to do, to hopefully I can keep these people have a place to stay, and just pay my tax, do what I can do because the house is not very. How you say that? I'm not really making a lot of money from that house. To me, it's just kind of a property I own. That's it. Thank you.
Mm-hmm.
So they're month to month is the question.
Yeah.
The tenants are month to month, so they have to have 60 days notice to
But
move
they
out.
have been long-term residents?
Long time, yeah.
Okay. Anybody else on the board have questions?
Any other commission has a question for the applicant?
Of the applicant.
Commissioner Anderson?
Sorry. The house is 1,800 square feet? Is
Yeah,
that-
total is not big. Yeah, it's 1,800 square feet. When I purchased, it's already set up as is. I have never fixed it.
Uh-huh.
The only thing I do painting and a carpet. I put a new refrigerator, stove. That's about it.
And there, you said there are 4 people?
Four, and one is probably going to nursing home very soon. She has Alzheimer or stroke, something going on. She's in hospital right now.
Okay. And is I'm assuming this is a single-story house?
Yeah.
Okay.
It is, yeah.
Great. Thank you.
Thank you.
Any other questions from commission? Okay, back to you, Commissioner Dan.
Okay, I would like to talk to staff now. Y'all can step down.
All right, thank you.
But one more question. So even though those folks need 60 days' notice, they have been long-term tenants, is that right? Okay,
Right.
thank you.
They've been there since 2009 or 10.
Okay. So either Mr. Peterson or Jeannie, staff's recommendation was for denial, and can y'all explain the basis of that recommendation?
Commissioner Dance, the staff did recommend that the application be denied, in part due to the land use plan, which caused this to be a commercial category, like most of the other things down the road. And number 2, it just, zoning it residential into a more intense residential district, it may cause conflicts in the future with how properties developed around it.
So do you have a comment about that single-family residence, former single-family residence zoned LRC? Do you have any knowledge about that, what was presented?
Well, that did come in a few years ago to be a residential category, I believe RD also, and the board deleted that to LRC to be in compliance with the land use plan and to prevent future conflicts in the future.
Okay, but you're not aware of the current status of whether it's occupied or not?
Have no idea.
Okay. Let me ask you a question. If this were denied and they have a situation with longstanding tenants, is this something that could come in for a SLUP?
For what?
To allow more than two residents who are non-related?
It could come in for a land use permit.
Huh?
It could come in
LUP.
for, LEP to allow more unrelated people than what the code permits.
I'm sorry. Yeah, to allow more people than the code permits.
Correct.
That would be a remedy, potentially. Is that
Possibly.
correct? Okay. Okay. Are there any other comments that you'd like for the board to consider?
No, ma'am.
Okay. Anybody else?
Hey, Commissioner.
Not really so much a question. My comment was just, a little bit of a question. Looking at what we have in front of us, it looks like the predominant nature of the area is commercial. Is that a fair statement?
Correct.
Okay. So is there some thought that if we allowed more than one or more than two unrelated people to live in this structure for a period of time, that this was in any way harming any of the commercial activities adjoining here?
It may not.
Well, I'm sorry?
It may not.
Okay. Thank you. Okay.
Any other questions from commissioners for staff? Okay, back to Commissioner Dance.
Can I ask a follow-up question of the commissioner? So can you follow that thought as to what you think might be appropriate here?
Just looking at what's already around it, it would just seem to me, and I'm not nearly the authority that my fellow planning commissioners who've served on ComDev or done massive planning work before or large real estate investments, but it just seems to me that getting tenants, this is not really going to be a ideal owner-occupied R20 situation on this street. That to the extent you can find tenants as renters, this is, and right now that's there seems to be more of a demand than supply for rental property in this county. So seems to me what we can do to facilitate in the short term some sort of residential rental use of this, that might be the highest and best use in the short term. Perhaps in the long term, though, the highest and best use is something commercial. But those are just my thoughts, just looking at this map. And again, there are people on here with more experience than me in that regard, but those would be my thoughts.
Mr. Hughes, you have any thoughts?
I think Commissioner Boulogne brings up a good point with respect to residential rental maybe being a higher demand in this county right now, at least in the short term. So it might be something we consider.
And the thought would be, how might we consider that?
I'd actually lean on staff to see if there's an option there for us to consider. It sounds like land use permit is an option.
Right. Okay, I'm going to go ahead and make a motion, and I would move to recommend denial as staff has recommended. However, to encourage discussions between the applicant and staff in the time remaining before the BOC meeting to see if there are other options or recommendations that might be made.
Second.
So we have a motion, and it's been seconded by Commissioner Hughes. Any discussion? Yeah.
Briefly, would perhaps holding it be another option that you would entertain? Just holding it for 30 days so we could see if we could work with staff to find another option? If there's not any immediate risk of harm out there.
If that's a substitute motion, I would second it.
That's fine. That could be considered one. Just hold it for 30 days. Let's see if we can find something creative. I think we're just really struggling to try to find a way to make this work for everybody concerned.
Right.
So are you making a substitute motion?
Yes.
And I seconded it.
Motion.
Okay. A substitute motion has been made, and do we have a second?
Yes.
So substitute motion was seconded by Commissioner Dance to hold Z5 to give the applicant time to discuss with staff. Now, y'all have sent me down a rabbit hole, and I have to ask some questions. Do we have to vote on the first motion, or does the substitute motion supersede it now?
Right now, you just take the vote on the substitute motion, and that would supersede the other motion once that has been disposed of.
Thank you. Okay, do we have discussion on the substitute motion? If not, let's call the question. Okay, by a vote of 5-0, it is recommended that we hold case Z5 for 30 days. Thank you.
Okay, next case is rezoning case Z8, Streamline Development Partners. Request rezoning from NRC to NRC for retail, commercial, and restaurants in land lots 68 and 165 of the 18th District. The property is located on the east side of Hickory Trail, on the southwest side of Veterans Memorial Highway. The applicant's representative is present. Is there anyone here in person opposed to rezoning case Z8? No? Okay, let the record show there's no one here in person opposed. There are 7 people signed up virtually to oppose this case. At this point, I would ask the applicant's representative to come forward to present his case.
Good morning, Mr. Chairman. How are you today? Good to see you. And congratulations on being appointed, elected as chairman. And I also want to congratulate the chairman of the vice chairman, Mr. Hughes, on his election to lead the planning commission as well. Good to see you all this morning. For the record, my name is Garvis Sams. I'm with the law firm of Sams, Larkin, and Huff here in the city of Marietta. And I have the pleasure of representing Streamline Development Partners concerning this application for rezoning. This is an application where we have our engineer and the principal of Streamline available, so the 3 of us can respond to any questions, Mr. Chairman, you have at the appropriate time. I've handed out some documentation and information, and I'm going to be following some of that in connection with the presentation today. As you can see, the property is shown there at the pin corner, or the northwestern quadrant of the intersection of Hickory Trail and Veterans Memorial Highway. The totality of this property is within a neighborhood activity center under the county's future land use map, which contemplates any and all the uses proposed by Streamline with respect to this, which are retail and restaurants. You may or may not be aware of this, but this property, and I know Mr. Hughes is, since it's his district, But this property was a part of a 16.05 acre assemblage that came before the Board of Commissioners back in 2016 for a special land use permit and a rezoning. It was for a private school, the SAE school, which ultimately either built or leased somewhere else. But at that time, in 2016, the plan included a 96,000 square foot box school, athletic fields, numerous athletic fields, and the attendant parking and things that you would typically expect to see with a private school. Unfortunately, the school never closed on it, and there were no reversionary, there's no reversionary language in there, so it never reverted back to its original classification. So right now it's frozen, both pieces, both of the two tracks that are part of this assemblage, because there's no legal entitlement to utilize them for anything whatsoever, unless you're going to build a school with a 90+ thousand square foot box and the associated things that you typically see. So that being the case, since 2016, this property has sat undeveloped, idle. There was an application that was filed last year to rezone the western portion of this tract specifically for an auto zone. We encountered some opposition. We enjoyed staff's recommendation for approval, but encountered some opposition that within the time frames allotted to us contractually we weren't able to satisfy. So it was made clear to us that we also should treat this particular intersection a little differently than perhaps others, because without having that pin corner that, as you can see, we have now, we have the totality of 3.804 acres. So it's 3 times the size it was, but includes another building approximately 3,000 feet, or a couple thousand feet smaller than the auto zone, which is still, as you can see on the eastern side. Since the action taken by the board in allowing us to withdraw this application, we met with the district commissioner and the zoning committee for the Mapleton Improvement Coalition. We've had a good dialogue with them, interesting and collegial conversations until we get to one component, which is the auto zone. And as former Chairman Beloin put it at one time, and probably didn't end up thinking he'd be quoted on this, but parts sales places for South Cobb in District 4, kind of like the climate control self-service storage facilities in District 1. They're just either not appreciated or maybe not understood. But in any event, we looked at a preponderance of the properties up and down Veterans Memorial. They're all commercially oriented. Actually, there's a light industrial on the other side of Hickory from us, but they have been looking at this site literally for years because the demographics are there to support it in terms of AutoZone. It's at a very critical intersection. It actually provides a step down of uses, and going back, you can see you've got our property, and then you've got the properties that are zoned commercially. If you venture further south, you run into property owned by Bankhead C&D, which is a recycling operation. It's that part of their property is not developed, and then Zoe Christian Fellowship, which is across Hickory. The nearest subdivision lot's 206 feet away on Azalea Drive. So we've got a pretty decent distance between us and any residence whatsoever. This is the site plan. It shows the 2 buildings to be built. The one on the pin corner will be a restaurant or retail or a combination of the both, or the 2. And with the handout, you should have, and you have in the stipulation letter, the type of restaurants that we're looking at. There's enough drive-ins, fast food, fast casual. So we're looking at different concepts here, white tablecloth, sit-down type restaurants, and potentially a commercial component. And that's the reason we generate this list. These are the folks that Streamline is presently talking to for the site. There's been, the site being the pin corner, there's been a lot of interest that has been expressed. If you look at the, we've got one sole point of ingress and egress on Veterans Memorial. That'll be co-utilized by both the properties, and that will be right in, right out only. The only other point of ingress and egress is one on Hickory, just to provide interior and better circulation, both for the customers, but also for the fire department as well. We submitted some architectural renderings and elevations on this. This is taking the imagery of the architecture, both the composition and the style, and sort of inserting it in the corner. Those are the real trees that are there now. And that gives you an idea of the milieu of development, or the context of development within which this property is situated. We're agreeable to all of Mableton Improvement Coalition's recommendations, save and except for two. One, they don't want the storage, excuse me, the parts building in terms of trying to dissuade types of uses that are more mom and pop oriented. But, and of course, everyone knows now that this particular parts store is a Fortune 500 company. It's publicly traded. There's numerous economic development directors that would give anything to be able to have this as a tax revenue source for this area. The building on the corner there, you've seen the list we've got. It's either a restaurant or retail or a combination of the two. In our stipulations, we have, the only other thing we can't agree with Mableton Improvement Coalition is they have recommended that we contribute $50,000 to signalization at this intersection. Now, if we're approved, that's certainly a discussion we can have with the district commissioner between now and when this comes up in 2 weeks. But if not, the signalization for that intersection is not warranted, and it really wouldn't make sense to bank money on a project that has not been approved. So we're in a little bit of a conundrum there, willing to play ball, and we don't, even whether it's warranted or not, truck traffic on this part of Veterans is insane and needs to be slowed down any place you really can. We've agreed to this architectural style and composition. We've agreed to architectural oversight committee to bring Mick into the process. We've agreed to a landscape oversight committee to bring Mick again into the process, not to the exclusion of staff or the district representatives, but just to bring them in the loop, and also to make sure that we comply with the Mableton Parkway Veterans Memorial design guidelines that you have from an architectural perspective. There's no outside storage, and one of the concerns that is with any parts place is, well, are they going to be outside storage? Are they going to be working on cars in the parking lot? If you look with specificity at my stipulation letter, we've even gone down to the complementary things that this company does: battery replacement, light bulb changes, wiper blade, et cetera. None of that will be allowed outside of the building. We've agreed to one sign for each building, like Mick wanted, except for prototypical identification signage on the buildings themselves. We've agreed to all the stipulations and conditions by the Department of Transportation and also by your Stormwater Management Division. And this shows a good idea of the prototypical distance between the buildings and gives you sort of a side view of the AutoZone and the restaurant retail. This is that list, and I know I'm not about to spend time going through them because I'm out of time. But that being said, your staff has recommended approval. In fact, this was actually on a consent agenda that staff had formulated prior to you considering. So that being said, we do ask that you recommend that this application be recommended for approval to the board. Thank you, Mr. Chairman.
Thank you.
Sorry I went over the time a little bit.
18 seconds. But can we hear, is the opposition here or online, I think? They're all virtual. Okay. So we will reset the clock and go to the virtual opposition.
Our first virtual opposition is Dominique. Dominique, you are unmuted. You might need to turn your volume up or speak up.
She keeps muting herself.
Make sure that you're unmuted on your end as well.
And she is no longer on the list.
Okay, we'll move to the next one. Ray Thomas. Ray, you are unmuted.
Mr. Thomas?
Yes, good afternoon. Well, it's still morning. Good morning. I too would like to, first of all, my name is Ray Thomas. I'm the chairman of the Mapleton Improvement Coalition, also chairman of the Mapleton Homeowners Association Network, which comprises of 20 HOAs right now. And I too would like to extend congratulations to new Chairman Vaught and Vice Chairman Hughes. And to the rest of the board, thank you for having me this morning. I'd just like to make a couple of brief points, and then I'll turn it over to others. Mr. Sands, in his presentation, mentioned that we may be misunderstood about the saturation or the concern about the number of auto-related businesses that are in our community. I respectfully say that we are not misunderstood, nor are we confused. Quite frankly, one of our residents in our HOA network counted 22 auto-related businesses in about a 3-mile stretch along this corridor. We have opposed this particular auto-related use before, and we are opposing it now. And the reason why is because we have a saturation of these types of businesses in our community. Would like to, and we have been working hard to try to assist the county and others in developing a more diverse business base in our community, which we desperately need, particularly with the increasing residential component that we have in the community. We definitely want more businesses, but we'd like to see a more diversified base of business to come into our community. Mr. Sands mentioned that there's no residential within, I think he said 220 feet of this property. That is not entirely correct. Right across the street, there is a development, and across diagonal to the subject property are residential homes that are less than 200 feet away from this property. So we are opposed to any additional auto-related use on this particular piece of property, and we asked the commission to recommend approval as well. I'll turn it over to others.
Thank you, Mr. Thomas.
Our next virtual speaker is Robin Meyer. Robin, you are unmuted.
Good morning. My name is Robin Meyer, and I chair the Mapleton Improvement Coalition Zoning Committee. And I'd like to make a few points in addition to Mr. Thomas's points. We appreciate that this application fulfills some of the issues that we saw with the prior application, in that it does include the entire corner, not just part of it, and the access to Hickory Trail, we believe, is a positive. However, historically, please realize that in 2018, the Board of Commissioners denied an application to locate AutoZone specifically in Buckner Crossing, immediately across Veterans Memorial from the Streamline property. Last year, Streamline's application for AutoZone was withdrawn after your recommendation to the Board of Commissioners that AutoZone not be approved for this location. The community continues to oppose AutoZone, as does the Mapleton Improvement Coalition. We would ask, however, that you recommend approval of this application because we fully appreciate that this corner is not properly zoned now, that it does have potential to provide the kind of diversity of business that our community needs. And that can't happen so long as it's zoned for a private school, which is decided to stay where it is on several miles away. But with that recommendation of approval, we would ask that you prohibit, just as we ask for for virtually every commercial zoning, prohibit vehicle-related uses, including but not limited to auto parts stores, auto repair, auto sales, so on and so forth, as you saw in my comments letter. That you prohibit fast food restaurants on this property. Although the restaurant building presently does not show a drive-through window, we want to be plain and clear that we are also pretty well filled up with fast food. And then it's extraordinarily important that the other usual prohibited uses that we've outlined in our letter that Mr. Sams typically includes in his stipulations letters also be attached to this property, because we do not know how the building now labeled as restaurant will be developed there. It says restaurant in the site plan, but Mr. Sams has also referred to it as retail, and we would not want to see, for example, a pawn shop or an auto parts store in that building. The installation of curb, gutter, and sidewalk along Hickory Trail is a bit unclear to us. We would like it to go in the entire length of the applicant's property. And we feel strongly that a contribution needs to be made towards the traffic light at Buckner and Veterans, regardless of how this property, of the businesses that locate on this property. The contribution wouldn't need to be made until until immediately prior to a certificate of occupancy being issued. So we're not asking for a payment now and development 10 years from now. We're asking for that payment when the development is close to maturity. So with that, we would ask that you recommend approval of the application, but make it very plain that neither AutoZone, auto parts, or fast food restaurants will be a use on this property. Thank you.
Okay, Ms. Goldrick is back on. Ms. Goldrick, you are unmuted.
Good morning.
I think we might have lost her again. We do have one more, so we can move on to them. Marissa? Elliott? Marissa, you have been unmuted. Ms. Elliott?
Ms. Elliott, can you hear us?
Yes, can you hear me?
Yes, now we can.
Oh, hi. Good morning, everyone. I'd like to extend congratulations to the chairman and the vice chairman. Thank you so much. I wanted to speak in opposition of the AutoZone. As has been previously mentioned, this corridor is completely and utterly overwrought with car repair places and things of that nature. And myself living within yards of this proposed construction is going to, I'll see a drop in my property value, and that is something I do not want to see. Some things that I heard were how that corridor was going to be developed. Again, AutoZone does not need to be placed there. There is no way that you can control what happens in the parking lot of a business. And I have seen the same things that were mentioned that won't be allowed being allowed. People changing their oil, making small repairs in the AutoZone parking lot because they've gone inside to make proposed purchases. Those types of things cannot be seen in this particular community with the type of rooftops that we have here. It just cannot be sustained. I cannot sustain my property value, nor can my neighbors and members of my HOA. Fast food. This is a virtual food desert. We have enough fast food restaurants here as well. So, again, I will make this short. I am opposed to Z8. Thank you so much.
Thank you. No one else.
That's all we have. Ms. Goldrick continues to be online, but I don't think we are able to connect. Nope. Ms. Goldrick?
If you'll turn your volume up, we hear something.
Yes.
Hello, are you there?
I need to give my time back. I'm not in a place where I can talk right now.
You said
That's why I continue to mute the.
we can hear you right
I can't
now.
talk right now.
We can hear you. Okay,
Yeah, I can't talk.
thanks.
Okay, I just have to go back on mute.
Thank you.
That's the end of our virtual.
Okay, that's it for our virtual. Thank you. As this is again, in Zone 4, I'll turn it over to you, Commissioner Hughes.
Thank you, Chairman Vaught. Is DOT available?
Yes, DOT.
Hey, Amy, just a question with respect to a couple of things. I think one of the conditions I think Mick included in their letter called for the installation of curb gutter and sidewalk along Hickory Trail. Is that DOT's recommendation? And is it for the extent of the streamlined property?
Since that area is currently a rural section and does not have a lot of traffic on it that we're anticipating, we had not recommended that. It would be acceptable to DOT, assuming they can design the drainage structure to go along with the curb gutter and sidewalk, because they'll have to feed back into the rural drainage further up the road.
Gotcha.
So that would be that. If that is a condition put on by, a stipulation additionally put on the facility, we can work with them to make it work.
Okay. And then I think in the Mableton Mick improvement or conditions letter as well, they referenced a financial contribution for the installation of a light. I've heard that was a condition for the Buckner Crossing Center across the road there. Can you confirm that's accurate?
That is accurate. There was a financial condition. I'm not certain if we're still holding on to it. The issue with that light is that is a GDOT roadway, being Veterans Memorial Highway, and they have not approved a signal warrant study there. So they've done them and said that the signal is not warranted. And so the county has no option for moving forward if GDOT doesn't support the signal. I know for at least a time, Buckner Crossing had money escrowed toward that signal. I would have to research to see if it's still in escrow holding for the future development of that signal, because we do anticipate it to signalize at some point. I would recommend that this development have the same thing, that the development agreement would be for money to be put into escrow for that signal. And then what we're doing now is we're trying to put a time limit of 3 years, 5 years, whatever, so that if it does not build within that time period, we can then refund the money back to the developer.
Okay. Can I ask you to maybe do a little research to determine the status, if that money is still, what was escrowed for the property across the street is still, in fact, in escrow?
I can do that.
Okay, and then if you could just email the commissioners, I would appreciate it. Anybody have any, that was all I had for you, Amy. Thank you very much. Any other questions from DOT?
I think we have one from Commissioner Boulogne.
Thank you. I'll direct it to you, Commissioner Hughes, and you can pass it to Ray or Robin or whoever you like if you don't want to answer. Just curious about the mix in here in terms of reasonable economic use, and if they're not allowed any fast food in addition to not being allowed pawn shops, auto parts. Are there other restaurants within, say, a quarter mile of here that have succeeded over the years, for example?
Make sure I understand your question.
Other non-fast food restaurants. So, for example, I come from a part of the country where my children, who are all grown now, but they like to joke that New England is nothing but cereal Dunkin' Donut shops. But I'm just kind of curious, the success rate of restaurants within, say, even a half a mile of here that are not of the fast food variety. What do we have right now in the area is my question.
So I know at the corner of Discovery and Veterans Memorial, there are 2 restaurants there on the southwest corner. Mooyah Burger is one, and there's another restaurant in there. The the name of that restaurant escapes me right now. And then across the street in the Providence Public Shopping Center, I know there's a restaurant in there as well, and a Marco's Pizza as well. Those are at least a couple that come to mind. If some of our virtual participants know of others in the area, I'm happy to defer to them if there are others that they're aware of.
This is Amy Diaz. So Providence Pavilion has several restaurants. Whether or not you classify them as fast food is they're primarily fast/pickup. Not there is a Wendy's that is a fast food with a drive-through window, but there's a Subway, there's a new a Chinese restaurant, and there is, I believe, one other restaurant in that basically mostly serves pickup for their food or Uber Eats or whatever deliveries.
Other questions by other commissioners or staff? None? I'll turn it back to you, Commissioner Hughes.
Thank you. So I want to thank the applicant's representative. Had an opportunity to meet with them last week to discuss this case. And I thank the community also for your emails of concern with respect to this auto-related use that's proposed. I'm also sensitive to, I think, a comment that the applicant made with respect to how the site is currently zoned. It's obviously currently zoned for a private school that appears is not going to be moving forward, so that limits, obviously, opportunity for development unless this property is rezoned to another use. I think the NAC and NRC zoning that's being requested seems reasonable. I think what it comes down to is the actual type of business that's going in. Clearly, the community has concerns about auto-related uses that are prominent up and down that corridor. I think based on that, my recommendation would be to approve this, but subject to a series of conditions. And this may take a little time for me to sort of read this into the record because they're really there's a stipulation letter, and then there's also a letter from the applicant, and then there's also a stipulation letter from the community. But I'm going to try to read this if that's okay with this group. So my recommendation is to recommend approval of the application subject to the zoning stipulation letter dated January 20th from Sams Larkin Huff. I'm recommending that stipulation 2 be revised in the following. The approval of the application shall be specifically for the purposes of the construction and development of a 6,170 square foot restaurant with possible retail component on the Penn Corner track and an approximate 7,430 square foot retail store, period. Next sentence, said restaurant shall not be converted into a restaurant or into a fast food drive-through feature, period. And then I'm going to incorporate 2 points from the MIC letter that's dated January 26th. In the January 26th letter, they read as items 1 and 2. They're going to be 3 and 4. Does that make sense? Yeah, okay. No vehicle-related uses, including but not limited to auto parts stores such as AutoZone, auto repair, auto sales, new or used tire sales, emissions inspections, or similar service or sales for cars, trucks, or other motorized vehicles for the entire parcel. Next one. The following additional prohibited uses would be liquor store, adult entertainment, sales of sexually explicit or drug-related paraphernalia, pawn shops, title pawn shops, gold or precious metal dealers, nightclubs, video arcades as a primary use, check cashing, discount sales, and dollar stores, drive-through windows, taxi dispatching services, wholesale wholesale only in sales establishments, gun, knife, or weapon sales, shooting ranges, firewood sales, thrift stores, secondhand stores, or flea markets. Then going back to the January 20th letter, I want to change stipulation number 5 to read as follows. The proposed operating hours for the restaurant, non-fast food, and retail component will be daily from 7 a.m. to 7 a.m. to midnight. The proposed hours for the operation of the retail store will be determined by an other business item to be considered by the Board of Commissioners. All other stipulations in the January 20th letter would be appropriate. And that is my motion.
We have a motion by Commissioner Hughes. Do we have a second?
Second.
Second by Commissioner Dance. Discussion? Commissioner Ballone.
Thank you, Mr. Chairman. Just very briefly, it was important to me to hear that there are other restaurants that are successful in the area, not of the fast food variety, which indicates a reasonable economic, an alternative reasonable economic use. Also important for me to hear from Ray that there's another AutoZone within 4 miles of this location. So it seems like there's at least an opportunity for consumers to avail themselves of that store and their products without driving too terribly far.
Other discussion? Commissioner Anderson.
Only on other clarification on this. Is this AutoZone expected to be a new ground-up one or a replacement of another location? Do you have?
That might be a question for the applicant.
I don't know if you happen to know that. I might ask the applicant. Sorry about that.
No, no.
Sure.
It's ground up, and to supersede and replace the ugly-looking AutoZone that you saw down the street with the architecture that we depicted today.
So that one will be refurbished, or it'll be altogether just shut down, the other one?
This will replace that.
Okay, so net, there's no increase in the number of AutoZones?
Yes, sir.
Okay, got it. All right, thank you.
Thank you.
Other questions as it relates to the motion on the table? None? If not, we'll call the question. Sorry, confirmed by a vote of 5-0 to recommend approval of Z8 with all related stipulations as noted. Thank you. With that, we are going to adjourn for lunch and resume at 1 p.m. Okay, welcome back to the afternoon session for this February 1st Planning Commission zoning hearing. Mr. Peterson, if you'll call our next case.
Yes, sir. Rezoning case Z9, Windsong Properties. Request rezoning from R30 to R20 for a single-family subdivision in land lots 79 and 144 of the 19th District. The property is located on the north side of Dallas Highway and on the south side of Old Dallas Road, west of Holland Road. The applicant is present. Earlier, there were 12 people here in person opposed and 2 people here virtually opposed. All those folks here in person wishing to address the board, please come forward and be sworn in.
Do we have everyone sworn in? Yes, okay. Awesome. Let's turn it over to you, Mr. Sams.
Thank you, Mr. Chairman. Again, good afternoon. Good to see you. For the record, you and members of the Planning Commission, my name is Garvis Sams. I'm an attorney here in Marietta of the law firm of Sams, Larkin, Huff, and represent Windsong Properties concerning this application for rezoning. I have Mr. Henry Massey, Windsong's land acquisition manager, here with me today. Also, we have from our engineering firm, Mr. Chad Lambeth with Planners and Engineers Collaborative, who's our civil engineer and can respond to any questions you have from an engineering or technological perspective. Also, Mr. Massey, with his number of years in the development community, is well-versed in most, if not all, the issues that may or may not be brought up. This is an application that, as you know, was on your consent agenda this morning. It came out of your Planning Commission meeting on the consent agenda. And even though it's nice to have a case on the consent agenda, it's just probably was fortuitous that it was taken off, because it gave us an opportunity to get to know the folks that are here in opposition or concerned about this, to chat with them and find out where they were coming from. And trust me, it's not that we haven't made overtures and attempts to speak with people, but it was a pleasure meeting them today, and I hope we've at least started a good dialogue that can go on over the next couple of weeks. This property that you're going to be looking at is a 20.11 acre tract of land. As you can see, it's located on the north side of Dallas Highway, south of Old Dallas. If you look down in the bottom, or I guess it would be the southwestern corner of the property, that building there, that's racetrack. And the Cobb County Paulding line goes right smack dab through the middle of that. We rezoned that and entitled it for racetrack years ago. And as a result of that and some other activity in the area, back in 2007, the future land use map was changed to reflect the racetrack and everything up to our property line, which you can see outlined on this, is in a neighborhood activity center. And you can see it stops right there, and it lops off part of the racetrack, but you can see where the county line is, and you can see where the future land use map shows neighborhood activity center. Everything else that you see north and east and south of this is VLDR, very low density residential. But that also includes the subdivision directly across Dallas Highway, which is Pickens Point, which I rezoned about 3.5 years ago. That's an R20 OSC, which is at 1.75 units per acre. And if you go further east, back towards Marietta, near the transfer station, before you get to Lost Mountain Road, you've got another subdivision that's CS that's at a 1.34 unit per acre. What we propose, what Winsong proposes here, is a rezoning of this property from R30 to R20 for the purposes of a quality, custom-built, single-family residential subdivision consisting of a total number of 25 lots at a density of 1.24 units per acre. As you know, VLDR allows densities anywhere from 0 to 2 units per acre. So we're at the very bottom end, bottom range of that VLDR. And actually, we're only at 3 lots more than what could be developed without agreeing to any stipulations or any conditions or doing anything other than going through the plan review process to go out and turn dirt on the property today. Of course, there's some developmental constraints. There's rock on the northeastern part of the property. There's a stream which traverses it, so there are developmental obstacles. And whether we mathematically could have maxed out the 3 more lots or not, who knows? But we didn't, and we're at 1.24 units per acre. All the lots meet the 20,000 square foot requirement. We are not asking for any variances to lots, their setbacks, buffers, anything. We're not asking for any variances at all. On January 21st, we submitted our stipulation letter and followed up that letter on January the 24th, depicting the architectural style and composition of the buildings, the homes. You can see those in the handout that I've provided to you. Also, you can get a good idea of what Winsong's product looks like. Even though Winsong mainly does age restricted and it's the cottage style, these are just standard single-family detached residential, non-age restricted residences that will range anywhere from 2,400 square feet to 3,000 and beyond. And the price points, even though that's not part of your consideration, but interesting to note, the price points will be all north of 800, 800 and 900. But to give you some ideas about what their homes look like, very finely constructed, craftsman style, and sometimes incorporating the sort of this modern farm-like feel. Not my cup of tea, but a lot of people seem to be liking it, particularly white houses. I haven't gotten by that yet, but a lot of people are doing white houses now. It's my own personal thought. But in any event, I probably tick somebody off by saying that too. With the discussions we had today and putting those with the discussions we've had with the district planning commissioner and the district commissioner, we've had some good discussions, and staff, of course, is recommending that this application be approved. We did have a previous application on this property last year for an RSL, but it was at a density and an intensity that, notwithstanding its contiguity to the activity center, was just a little too much, and it was for 40 some odd homes. So we've significantly scaled that back and, of course, not age restricted this. Again, 25 homes, maximum density of 1.24 units per acre. The stipulation letter gets into all the details regarding the landscaping, and the front sides and rear yards will all be sodded and irrigated, and the detention and water quality areas will be, of course, screened. We haven't agreed to it, nor has anyone asked us to, but be pleased to set up and have a representative of the neighbors participate in a landscape oversight committee when we get to that point. Of course, as you know, even though there's a 40-foot construction buffer during the construction and build out of this property, there are no requirements for buffers from residential to residential unless you're involving a multifamily or perhaps an RA5, which requires a buffer strip. But nevertheless, some of the things I've heard, speaking with my client, an engineer who spoke with the folks outside as well as me for a bit, is perhaps they're looking for some more separation between their homes and our homes. And since we have no variances, we have the ability to be able to move the houses on the envelope or in the envelope to the extent we need to, except to the extent where we have the constraint of the stream on the one side, which might make it a little difficult. This is an oddly configured lot, and it belongs to a church, and they're the ones that are our sellers. We are installing curb gutter and sidewalk along Old Dallas Road, 10-foot, no access easements, so no individual homeowner can pop out a driveway onto Old Dallas. The lighting is going to be low intensity, environmental type. Lining the streets are public streets. This is not a private street situation, even though there will be a mandatory HOA with price points up as high as these will be. It just makes sense to have that, and also for the upkeep and maintenance of the detention area and other infrastructure within the subdivision itself. There's a Shirling Lake downstream. We're going to do a pre and post sedimentation erosion control study, one before, one after, and of course be responsible for any sedimentation that may have escaped the site and making sure that's taken care of. Under the Georgia Stormwater Management Manual now, we are actually required to not just control, manage stormwater runoff, but also to reduce it. And there's a specific formula for that, and Carl Carver, I suspect, is listening in, virtually can weigh in on that. But we've agreed to all the stipulations and conditions set forth by staff, including the Stormwater Management Division. This application, it exceeds the requirements, or is within the mid-range of the requirements for VLDR, the future land use map.
1 minute.
Thank you, sir. The future land use map embodies the policy and the intent of the board, as does the comp plan and the accompanying text that goes with that. So for all these reasons, we do respectfully request that you as a planning commission recommend approval of this application as presented to you today. So at the appropriate time, Mr. Massey, our engineer, and I can respond to any questions I may have. Mr. Chairman, thank you. That makes up the 16 seconds I went overtime the last time. Thank you.
Right at 16 seconds left. Thank you.
I'm just teasing.
We'll now hear from the opposition. We'll start with in-person, and then we can go to virtual.
Hi. Thank you for hearing our concerns. I'm representing the Old Dallas Road community, Brinkley Road, Cook Road, and some of the Antioch residents. And I do have some signatures I'd like you to add.
Could you state
to
your
this
name
meeting.
for the record as well?
Sandra Dupree, and I live at 5750 Old Dallas Road, which is directly across from the property. And a few concerns that we have is we'd like to keep the current zoning, of course, at R30 and not R20, just because we don't want future developments to say that we see this here, so we can do this here, because we have other developments going on, and they are at R30 in the area of West Cobb in our area that we live. So one of our main concerns is a water flood problem that we have that's downhill from this community coming to Old Dallas and down Brinkley. So we'd like to increase the water retention above what they already have, maybe to 140 and 150. And the reason that is, we have a lake that when it rains, it's almost at full capacity. When we have 2 days of rains, the road floods. We have no houses that have ever been flooded on Brinkley, but that's where the road floods, and we're worried about the road washing out. We're worried about emergency vehicles being able to pass through during times of inclement weather. So that's one of our main concerns. The other one is, of course, as we were mentioning, we would like some more buffering on 5723 from 30 to 50. We'd like to make sure that we had some fencing, some decorative fencing or some landscaping, which they've talked about, I feel like they're going to do anyway. And also, some of y'all have got emails about the traffic, and the traffic on Old Dallas Road going towards Paulding is essentially a one-lane road. And I know that's in Paulding County, but you have to yield to the other traffic when you're going that way. And that presents a safety problem for us. And that's one of the reasons we'd like their construction traffic to exit on East Paulding or Dallas Highway, either one of those, because it's going to present a problem. Only one construction vehicle of their sizes is going to be able to go down that road. Another thing we were concerned about is our road is dark. It has no street lights, and it's because we have 16 horses. Sometimes we have uppers of 20. We have several donkeys. We'd have all kinds of different farm animals, and their heads are down and asleep soon as dark. So we know we've talked about lighting, and we've talked with the developer about making sure they don't have any lighting pointed towards, our properties with our livestock, and that's what we were concerned about. And also another thing I would like y'all to know that we had numerous trees taken down when they were doing the perk testing, and we want to be protected to know that how that's going to be prevented in the future. We've sent an email to code enforcement. They haven't come out yet. We'd like them to evaluate all the trees that were already taken out and damaged. 5723, they took out trees there as well, to see the impact already of the development of the trees. Thank you.
Thank you. Next for opposition.
Hello, I'm Karen Major. I live off of Antioch, which is within less than a mile than where this construction is going to be. Everything she said are my concerns as well. In addition, the traffic is a big thing for me. I travel Old Dallas Road daily. The intersection at Holland Road onto Dallas Highway is a dangerous and a heavy trafficked area. The additional homes in this area are going to put 300 more cars coming through there daily. I myself have witnessed someone nearly being hit by a car crossing Dallas Highway to Holland because there's no turn lane to turn left off of Holland onto Dallas Highway. So please take into consideration the safety of our residents, the walking capacity. We need the sidewalks. We need protection for the people in the community. There are other areas close to me that are for sale now, 40-plus acres. There's going to be more people in this area over time, so we need to make it safe for everyone that lives there now.
Thank you. Additional opposition?
Hi, I'm Dr. Carrie Bayer, resident of Old Dallas Road, and many of my colleagues will tell you they're the seniors. They've been there a long time. Well, I bring the junior lens. I moved from a subdivision a year and a half ago. I know what it's like to live in a subdivision. I know what comes with it. We specifically moved to Old Dallas Road to bring our horses home, to have the agriculture, the pecan trees, the fruit trees, the other crops that we have on our farm. And to take a zone and move it from an R30 to R20 sets a precedence because as our senior group around here, one person moves or passes, that opens up a land space for many other houses to come in. I have a family who aspires to move in the equine industry in Cobb County and the ag industry in Cobb County, and we can't do that if you take and approve this and other applications in these areas of some of the properties that are left that are allowable and support our horses, our donkeys, our other livestock. We're raising kids in 4-H who want to stay in Cobb County, and we can't do that if everything gets moved into a subdivision with houses. And the piece around lighting, we actually enjoy being able to look up at the stars at night and not have light pollution, noise pollution. The tree barrier that is there protects from some of that. We don't want any of those things to go away. So yes, it is also, as reiterated, safety is a concern. My driveway is on a blind turn. When I have a horse trailer coming out of that driveway and folks speeding down, it puts my family and my four-leggeds are part of my family and show animals at risk. And so we need you to take that into consideration as you look at this proposal. Thank you.
Thank you. Any more in-person opposition? We got about 3.5 minutes remaining for opposition.
I'll try to be as quick as I can. My name is Jerry Dupree. I live at 5723 Old Dallas Road, and I'm totally against this for the reason that R30 was put in place to protect our neighborhood. We have a pristine neighborhood out there that's got the advantage of being convenient and also being a rural area. All the houses out there in that area sit on basically 2.5 to 3 acres or more property. Moving these houses in there at R20 is going to take that protection away from us. I've lived out there 55 years. I moved out there when that road was dirt and there was enough kudzu across the power line out there that if people either stopped right there because they thought the road dead ended right there, or if they came on through it, my wife and I knew that they were either lost or we had company. I've seen that road go from dirt to pavement. The only thing that the county has given to us out there is water. All the houses out there are basically on septic tanks, and a lot of them are still using well water. Myself, working with Cobb County, I was able to tap onto the water when it came down through there, which is a benefit, and I appreciate it. I can't even begin to tell you the changes that I've seen in the 55 years that I've lived out there. And the Dallas Highway has gone from 2 lanes to 4 lane. I remember coming in from work a lot of times before I went to work with the fire service. They had a caution light at Lost Mountain and Mars Hill Road. I knew if that light was out, I had lost power. I could go on and tell you many things that's changed out there, and I don't want to get into that. I just don't want that, what we've got left of it, to be taken away from us. And I would appreciate your consideration in leaving this at R30 instead of moving it to R20 and taking our neighborhood away from us. I appreciate your time.
Thank you. We have about 45 seconds left, but do we still have folks online?
We do. We have one.
Okay.
And Schroeder. Ms. Schroeder, you are unmuted.
I'll go ahead and speak. I believe I'm next. My name is Ann Schroeder. I currently live with my family in a home approximately half a mile from the scheduled subdivision to be built. And I'm speaking today in opposition of the proposed zone change from R30 to R20. As the first gentleman mentioned, the neighboring community is made up of custom-built homes on land lots or in subdivisions with lot sizes and home square footage that have lower density levels, specifically providing privacy and higher home values. The current R30 zoning is already of a size and scope that will have direct impact on the surrounding roads, neighborhoods, and schools. Moving to a higher density zone of less than half-acre lots would only further impact these areas and is not in alignment with the intent of the area. The new subdivision will have increased traffic on cross streets of Brinkley and Old Dallas Road, as the other folks have spoken in opposition, and move into a higher density zone. These are quiet, 2-lane winding roads and are not intended to be thoroughfares. By adding more homes, traffic will definitely increase on these roads. In closing, I would like to share that my husband and I grew up in Southern California, and as we raised our family, we saw what overdevelopment did to the area, specifically due to high-density housing. This was the primary reason we chose our home in the area it is in. I'm aware that development will occur. I do feel, however, that we all have a responsibility to ensure that it aligns properly with the intent of the area. And as such, I respectfully request that you take this into consideration for this zoning change. Thank you.
Thank you. The opposition went over for about a minute. Mr. Sams, do you want? Okay. With that, we are going to, this is in District 1, so I will turn it over to Commissioner Ballon to lead our discussion.
Okay, thank you again, Mr. Chairman, and thank you to everybody who presented out here today. What I'm seeing here is a situation where the tract is over 20 acres. The proposed density is so low that it tends to be more consistent with an R30 density, even though the request is for R20. The proposed change is 3 houses, and they are abutting a area already zoned commercial. And so my thoughts tend to run in favor of trying to get this done. If we can do it in a manner that addresses in significant part the concerns raised by a number of folks in the opposition, I think I don't see the change by 3 houses as being as material as some other factors that have been raised that hopefully we can come up with some either solutions to or mitigating actions that will help make this development less severe than it otherwise might be in terms of impact on people and livestock. But I wanted to start by asking for Amy Diaz if she's still out there. We heard from her this morning.
I'm still here, Amy Diaz, DOT.
Okay, thank you very much. What, if anything, can be done? There have been a number of questions raised regarding the intersection of Old Dallas Road with Dallas Highway. Is there anything we can do to check on signal timing or do anything to help alleviate the existing traffic concerns that have been articulated here?
Yes, so we had a email go out yesterday from one of our deputy directors about this location. So let me pull it up and I can give you some of that information. So we have the intersection at Dallas Highway is actually with Holland Road. So the Old Dallas Road intersects Holland, and then Holland intersects Dallas Highway.
Okay.
He has requested that his staff check the operation of the intersection for any potential signal efficiency improvements. And if warranted, they're going to do an adjustment to that. Additionally, he's asked them to monitor the eastbound protected permissive left turn movement. Okay, this is a different intersection, Dallas at Mars Hill, which was another concern that was raised by the public, to make sure that the signal triggering is worked correctly. You know, the signal loop there. And then we did want to note that we are experiencing increased volumes on Dallas Highway corridor right now because commuters are avoiding the Macklin corridor because of the GDOT widening project. So we are seeing some increased traffic on Dallas Highway that should shift back when that construction is completed.
All right, any other questions for Amy or DOT from any of my fellow planning commissioners? Okay, let me move to stormwater. Is Dave out there or someone else?
Carl.
Carl,
It's Carl,
sorry.
I'm here.
Carl, thank you. All right, Carl, what I'm seeing, based upon the streams that are shown on the map, it's a visual in front of us here at the meeting today, it seems like only there's one stream in the very far corner, the very far northwest corner of the parcel flows towards the lake, where one of the opponents has complained about a concern or has raised a concern. What thoughts do you have as to the extent to which this one creek or creek bed will cause a increased flow of surface water given the proposed project?
Yes, in my stipulations, I had part of the requirements is for them to provide a sediment study of Lake Fowler. I think it's Lake Fowler that's north of them. And so they would provide a pre and post developed sediment study there. And then as the new regulations for runoff reduction is required, we don't necessarily increase the stormwater detention requirements any longer because the new regulations are requiring them to show that they're reducing the runoff to start with.
Okay.
So it's about 700 feet north. And, you know, if there are problems existing up there, I'm not aware of those right now, but that comes into a different department within stormwater.
Okay, any other thoughts, concerns, anything we can do to further mitigate any requirements that you can think of?
Well, the detention system and the runoff reduction, the combination of that and the water quality requirements, they should be reducing the runoff going to that direction. And that's what we'd hold them to. In that far northwest corner, off-site to the left, to the west, there's another detention pond existing in the Paulding County area there. So all of those combined will have to be evaluated to develop the flows to that lake and in a downstream analysis as part of their regular plan review.
Okay, so you're comfortable with the plan review plus the additional stipulations you placed for a study?
Correct. And then to the south, there's Lake Shirling, which I'm also requiring a pre-development study there too, pre and post.
All right.
It's just on the other side of Dallas Highway.
All right, does anyone else have any questions for Mr. Carver?
Commissioner Anderson?
Hi, Carl.
Hey.
So just to help me understand, I know in your comments you referenced the DNR variance, and I think the applicant had mentioned no variances required, but given the some of the lots do overlap with the stream buffer, could you explain a little bit around like the impact of that on the site plan, and whether those whether there is a truly going to be a variance required this? I'm just trying to reconcile that with the comment earlier that there would be no variances required.
Yeah, based on this site plan, there probably will not be a DNR variance required. I think in my comments, I had mentioned that there may be a potential stream passing through Lot 11. And I think since then that Frank Gibson in our erosion control division has verified that that is not a stream.
Got it. Okay. Thank you, Carl.
Thank you.
Any other questions from other commissioners? Carl? Okay.
Okay. A couple of questions for the applicant then at this time.
I have one more question of staff, but should we come back after the applicant?
Sure,
But
that's
this would
fine.
be for planning staff. I didn't mean to interrupt.
That's fine.
Just for John, John Peterson, do the Dallas Highway guidelines apply for this site? And if so, are those restricted to just the area that's facing Dallas Highway, or are there any kind of impacts internally beyond those? I think there were some comments in the staff analysis saying that there were some guidelines that applied to this site. Just wanted to see if those really extended beyond just frontage on Dallas Highway.
There definitely are design guidelines referenced in the zoning analysis under the planning comments. Those mainly deal with non-residential developments, so I think what they're proposing would be okay as far as the houses go.
Okay, just wanted to confirm. All right, great, thank you.
All right, for the applicant again, there's been some discussion about tree removal to date. Do you know the extent to which the healthy forest that is shown in the visual we have now has been altered through the present?
When I turned to reprimand my client for that, he told me that a previous developer, Beazer, had it under contract, and that snafu happened then. Of course, they'll never engage me to represent them again, but that's what happened.
All right. So what are your landscaping plans for the boundary with the with lot 57T3 as shown here?
Mr. Massey has had some conversations with them. We've got plenty of room, Mr. Boulogne, to add, even though buffers aren't required residential to residential, we can certainly put in the buffers required. And you remember I mentioned the landscape oversight committee. That's not in my stipulation letter, but if you think that would be helpful, particularly with respect to those particular property owners, as you can see, there's pretty heavy tree cover on both sides of that, on both property lines on either side. But we can do whatever it is to either enhance it or to create something in addition to that, and with a fencing component, which I think might be lost within the actual existing vegetation. I think probably distance as opposed to screening is probably the more efficacious.
What do you think would be reasonable in that regard for a buffer?
Would we be allowed, Mr. Boulogne, to move the house forward on the lot a bit?
Yes.
I
would move for that, but
30 feet.
That probably can.
Okay. Tell them we're looking on the site plan now.
Yeah, I'm not talking.
Got 35 on it.
Mr. Massey can come up.
And use the mic, please.
I swear, man.
No.
Good afternoon, Henry Massey with Windsong Properties. As Mr. Dupree said, eloquently said, we currently have 35-foot buffer. We're going to look between now and the BOC. We're going to look at an increased 50-foot buffer from their property line to Mr. Dupree's property line. We're also going to look at potentially keeping the 3 lots. I don't have the site plan in front of me, but the 3 lots as you come in to the development, which are lots number, I believe it's lots 1, 2, and 3, to keep those lots for a 1-story product only. So it'll be less minimizing on the home across the street, along with the farm animals that are present on the Dupree children's property.
Okay. And what about along Old Dallas Road? What kind of landscape?
We'll have as traditional with most of, well, actually all of Windsong's community, we'll have heavy landscaping, both low intensity up front, and then we'll have buffering with a fence that goes along the frontage of Old Dallas Road.
Are you, in order to address or alleviate some of the silt concerns, would it be acceptable if we said no mass grading with grading limited to roads, building paths, and utilities, or is there some area here that specifically has to be mass graded for this project to work?
Let me consult my civil engineer here
Okay.
real quick, if you don't mind. What's that? So, as you know, we have rock that is present on the property, and we're concerned that that condition may confuse what we're trying to do with getting rid of the rock and the trench rock where the roads are going to, where the sewer line's going to go through the road. So at this time, I can't really agree to that condition. I can continue to look at it between now and the BOC.
Okay. Yeah, I think we'll probably need to do that. Do you know where this area is that you believe you have this rock?
I do.
Can you point that out?
It is located between lot 1, 10, 17, basically in basically in this area here.
In the
Located in
entrance
this
area.
area here.
Okay, but lot 22 does not have that? 22 and 23 do not have that?
We don't think so.
Okay, and similarly, the lots, starting at lots 4 and 16 and heading south from there, do not have that?
4 may, but below 16, no.
Okay, so 5 and 15 would be safe for that?
4, 5. I would feel more comfortable below 6 and, is that 14? Below 6 and 14.
Okay. Okay, does anyone else have questions for the applicant at this time?
Thank you.
Any other commissioners have questions for the applicant? Okay.
Okay. Thank you for that.
Thank you, Mr. Bowen.
All right. Does anyone else have any questions they'd like to ask staff or anyone else at all? No? Okay. I guess I'll move forward with a motion. My motion is that we approve the application with a series of stipulations. First, only low intensity and environmentally sensitive lighting is to be used with the district commissioner to approve the final lighting plan. Number 2, can I get those lots put back up here, please, on this? Okay. That's good. Thank you. Thank you. Oh, that's excellent. Thank you. Number 2, as to lots 22 and 23 and lots 14 and 6 and all lots south of lots 14 and 6 as shown on the rezoning master plan sheet Z4 dated 4/21/2021 by Planners and Engineers Collaborative, a small advertisement. No mass grading on such lots. And that's further defined to mean grading limited only to roads, building paths, and utilities. However, as to the lots not included and not expressly named or not defined as being south of lot 6 and 14, mass grading would be allowed there as necessary to allow the completion of the project. There shall be a 35-foot continuous landscape buffer along the east property line. And to the extent that that buffer has been invaded at all, the developers to provide new plantings with final plantings to be approved by the district commissioner. A stipulation should be placed in any covenants recorded such that the property owners are bound to maintain that 35-foot buffer for the next 20 years. There should be a reversion. There should be a reversionary clause such that the developer must pull the LDP within 18 months, or the property reverts to R30. The developer is also to provide a landscaping plan for the area along Old Dallas Road with final approval by the district commissioner. As far as items contained in the stipulation letter, to the extent they do not conflict with the conditions already stated, they apply, with the exception of the fact that as to DOT comments, all DOT comments apply, not just some DOT comments. That's the recommendation. Thank you.
So we have a motion from Commissioner Boulogne with a stipulation specified. Do I have a second on that?
Can I just ask for a repeat, Commissioner Boulogne, of the second stipulation around the lots?
I'm sorry?
The lot numbers and the exclusions.
Yes.
Okay, the lot
Sorry
numbers and
about that.
exclusions, it was to be no mass grading on lots 22 or 23, no mass grading on lots 14, 6, or any lots as shown on the Planners and Engineers Collaborative Survey. So the mass grading is only, any mass grading on this property is to be limited to lots 15 and 5 going north, but then excluding lots 22 and 23. The exception for mass grading on lots, on the lots that I enumerated where there's to be no mass grading, the exception, of course, has to apply for roads, building paths, and utilities.
Okay, so that motion by Commissioner Boulogne is still on the table with the associated stipulations. Do I have a second?
Second.
Second by Commissioner Hughes. Any discussion?
I have a question. Commissioner, does your motion include, or was it in, perhaps in some background documents, the discussion as to the restrictions on lots 1, 2, and 3 to protect the neighbors? Are those included in your motion or included in some sub-documents that you discussed?
Other than the landscaping plan, were there other specific concerns?
I thought that they made representations that they would construct lower storied buildings on those lots.
Okay. The applicant, can you come back up and address that relative to your stipulation letter?
Good catch. We did. Mr. Massey made that representation, but the way he couched it, we're going to have the marketing people look at it to see if it works. I can't think that it won't, but limiting those 3 lots to 1 story as opposed to 2 story. Looking at it, I mean, we haven't made that determination. We didn't have that question yet on the table until today.
But you're fine with the landscaping plan
Oh,
along
yeah,
Old Dallas Road?
Absolutely.
And you're going to look and try to, along lots 1, 2, and 3, limit those to 1 story, and you can have that answer before the Board of Commissioners meeting?
We'll have it in a couple of days.
Okay, thank you.
Is that then part of your motion?
No, I wasn't going to restrict it to one story as part of the motion, but
But the visitation of the issue, is that part
Yes.
of your motion?
yes. Please allow my motion to be amended by that additional stipulation that they will endeavor to allow for lots 1, 2, and 3 to have single-story houses if feasible.
The amended.
My second is still good.
Amended motion on the table, the second by Commissioner Hughes remained. Further discussion from any other commission? If not, let's call the question. It's by a vote of 5-0, recommended approval of Z9. Thank you.
Okay, next item is rezoning case Z11, Perkle Built LLC, requesting rezoning from R30 to R12 for single-family residences in land lot 771 of the 17th District. The property is located on the northwest side of Spring Hill Road, on the northeast side of Honeysuckle Lane. The applicant is present. Is there anyone here opposed to rezoning case Z11? No.
I'm going to start with.
Let the record show there's no one here in person or virtually opposed to rezoning case Z11.
Let me just pause for clarity. So that no one virtually?
Correct.
Okay. Okay, we'll hear from the client. From the applicant. Go for it.
Thank you very much, Mr. Chairman and Commissioners. I'm Kevin Moore here on behalf and pleased to represent Perkle Built Homes in this application for rezoning, which contained a fairly significant revision, even though it's a small project and property that was submitted to you last Wednesday. This property, which is highlighted for you on your screen, is just over 1 acre. It's 1.02 acres. It's currently zoned R30. What we are proposing in the initial application was to rezone the property to R12 for a total of 3 single-family lots that would be consistent with and match the R12 that's directly across the street, that's directly across Honeysuckle, where you see that's zoned R12. That was done in the pretty recent past. And in fact, Perkle Built Homes has built the homes on those 2 homes there that are zoned R12, and which led to the application and the basis for the application for R12 and 3 lots on this 1 acre tract to match that. When you look at the surrounding area, there is significant R12, RA6 across the street. You see other R12 developments in the nearby proximity, but then there's also R20 directly across Honeysuckle and R30 behind this property. So you have all of those residential categories, as you can see, in real close proximity to each other. But for your consideration, and after there was a good deal of evaluation on our part and on Mr. Perkle's part in terms of the proposal for R12 at 3 lots. Primary to that was stormwater concerns and stormwater comments which were initially made, and we worked with stormwater to develop any possible alternatives. But once a property is subdivided into 3 lots, it does trigger, and automatically does trigger certain requirements from stormwater. Those are trigger, development standards that come into play that can become expensive, and if you're only supporting 3 lots, it can become prohibitively expensive. We also reviewed staff's comments and looking at the overall picture here. With only 1 acre and proposing 3 lots, as staff's stated in its recommendation, that produced a density of 2.9 units per acre because you're only dealing with such a small tract. However, that does exceed the land use plan recommendation of 2.5. Given all of that, what we submitted last Wednesday was an amendment to our rezoning application that went with our stipulation letter. That was to request and delete the request to R20. Therefore, it's consistent again with the categories across the street for only 2 homes. That as a result of that, we did receive Mr. Carver's updated and revised stormwater comments that were received last Thursday, I believe. And those are agreeable, his updated and revised comments to reflect only 2 lots. Also, importantly, when you take it to 2 lots, that reduces the density to 1.9 units per acre, and therefore is consistent with the future land use plan's recommendation of up to 2.5 units per acre. So that fits within low-density residential, and it just becomes more consistent overall in terms of development standards, consistency with the land use plan, but yet still will be consistent with the R12 across the street. Homes are a minimum of 3,000 square feet in size, so these are very nice homes and will be well appointed as such. Given that change, we believe we are now within what staff would have recommended for approval if it had started as 2 lots, because it would have been within the land use plan, which was their primary objection. In addition, it allows us to now comply and agree to comply with all of Stormwater's comments and recommendations, which we can do, as well as the additional conditions and development standards that are contained within staff's analysis. With that, we would respectfully request your recommendation of approval of this revised proposal, seeking R20 for a maximum of 2 homes. Thank you. And there's the site plan. There's not much to see when it's just 2 lots, but there's the site plan showing both lots in excess of 20,000 square feet. And we're available for any questions that you may have.
Thank you, Kevin.
Thank you.
This is in District 2, so I'll turn it over to Commissioner Anderson to lead our discussion.
Great. Thank you for the presentation, Kevin.
Sure.
Not too many questions here. The only one, just more of a cleanup, seems like on the Spring Hill Road, sorry. The driveway shown there, that's the existing driveway, or ingress point, right? So that'll be going away. Is that correct? Is there a purpose for that being on the site plan, or?
That's picking up, I believe, the existing driveway. There still will be a driveway that will be aligned on Spring Hill for that first lot. We just have to make sure it's more geometry and distance separation for driveways from that intersection. DOT recommends a minimum of 50 feet for driveway separation from the intersection. So it's more of an arrangement to make sure that we can have compliant driveway intersection points that will align. So that's also done at plan review. These will be done with a house location plan as part of the building permit process to make sure that the 2 driveways are placed in their in the proper location that meet the development standards of DOT.
Okay. So for this plan, so the intention wouldn't be to have both driveways be on Honeysuckle at this time?
One would be on Spring Hill and one would be on Honeysuckle.
Okay. Thank you. And then I think the only other question was just more to confirm. For Lot 2 on the kind of northwestern boundary, that right now, that is a area where that's fully tree cover. Is that correct? There's no pervious surface at that time that's located currently in the site?
Right. I believe there's some trees along that area, correct.
Okay. All right. And do you happen to know if those that are there are of an evergreen variety, or they're just a bunch of pines, kind of softwoods, just?
Mixture. On Lot 2, it's in that back corner, there's just a mix of
Just a mix.
small trees.
Got it, okay. But there wasn't any buffer that was done beforehand, which?
No.
Okay,
No,
got it.
it's just a
naturally
mixture of
occurring.
small growth trees. Right.
Okay, got it. All right. Were there any other questions of the applicant from other commissioners?
Anybody else? No.
Great, thank you.
Thank you.
And is Amy Diaz from DOT still on the line?
I am Amy Diaz.
All right, hi, Amy. So just wanted to get your view on the most recent site plan with the 2 lots. The access point on Spring Hill Road, is that something Do you have any thoughts on that being there, or is that a preferred location for, or feasible location for driveway access?
Spring Hill Road is a minor collector, but it's not a particularly high volume one. It's certainly appropriate to put a driveway for the first lot on Spring Hill. It would effectively replace the existing driveway. So whether it's in the same place, you know, and they reuse that location, or if they close that location and move it to meet our standards, all of that can be worked out in plan review.
Okay. So thank you, Amy. Were there any other questions of the other commissioners on, for Amy on our DOT?
Any other question? No.
Okay. Great. All right. Were there any other questions of any other staff members? Okay. With that, then there are no other questions, prepared to make a motion for approval, subject to the following conditions. The stipulation letter dated January 26, 2022. The establishment of a 10-foot landscaping buffer along the eastern portion of Lot 1 facing Spring Road and along the rear lot line of Lots 1 and 2 with year-round evergreen visual screening. The requirement of a minimum of 20 feet between both homes, which I believe is reflected currently on the site plan anyway. All homes shall have a minimum of 2-car garages, and the garages cannot be converted into living space or used solely for storage. Each home will have a separate driveway, so no shared parkway. The driveway pads in front of the houses shall be sufficient to hold up to two full-size automobiles. And then the construction site will be considered a clean work area with loose debris disposed of each evening. Prohibition on stacking of vehicles along Honeysuckle Lane and Spring Hill Road. And provision of a 24-hour contact number to surrounding neighborhoods and posted on site during the construction period. Development and construction hour limitations for the project of 7 a.m. to 8 p.m. Monday through Friday, 9 a.m. to 6 p.m. Saturday, and no work on Sunday unless approved by the district commissioner. And prohibition on construction truck and worker vehicle being parked on site overnight. And then fire department comments and recommendations, water and sewer division comments and recommendations, stormwater management comments and recommendations, Department of Transportation comments and recommendations, planning division comments and recommendations, and all other comments not otherwise in conflict.
Commissioner Anderson, would you consider moving this to consent? My question.
Yes.
Yes.
Good call. Sorry about that. Yes, I would recommend moving this to the consent agenda if there's no opposition.
So we have a motion by Commissioner Anderson with associated stipulations, as well as moving this to the consent agenda. Do I have a second?
Second.
Second by Commissioner Hughes. Any discussion? None. Let's call the question. By a vote 5-0, it's to approve for recommendation Z11 with the stipulations as stated, as well as movement of this to the consent agenda.
All right, moving into land use permits on today's agenda. Next case is LUP 5. Rick Coleman requests a temporary land use permit for a firewood storage business in land lot 874, the 17th District. The property is located on the east side of Leland Drive, north of Windy Hill Road. Is the applicant present?
Yes, sir.
Let the record show the applicant is here. Is there anyone here in person opposed to LUP 5? Let the record show there's no one here in person or virtually opposed to LUP 5. Would the applicant please come forward to be sworn in?
Good afternoon, everyone. I know it's been a long day. Thank you for having me. My name is Dr. Rick Coleman. I have a chiropractic office on Leland Drive. There's basically three hotels on that road, and then my business. I've been there for over 5 years. I also have a chiropractic office off of Barrett Parkway in Kennesaw, and also own a home in Cobb County. So the three hotels are the Best Western, the Extended Stay, and the Country Hearth Inn and Suites. About 10 years ago, I had twin boys, and I grew up on a farm in Ohio, and I wanted to teach my boys work ethic, how to stay off of video games and stay off the telephone, and to put in a hard day's work. So they came to me one day and said, "Daddy, we want to try to learn how to make some money and incorporate hard work." So of course, I didn't start a lemonade stand. I got them to help me split firewood. And so we still to this day go outside, we work, we ride four-wheelers, we hunt, we fish. We do as much as we can outdoors and try to keep them off of TV and video games. And it's worked out well. I have two boys that are very hard workers. So we started, I had this extra space at the chiropractic office, and it's a very private road. I don't know how many of you are familiar with that road, but it's very, very private back in that road. It's a little seedy, if I'm allowed to say that, so I try to make it as nice as possible with my chiropractic office and have a great clientele. We had a lot of trees that came down from some of our properties and our farm, and we started splitting firewood, and over, and the next thing you knew, we had a lot of firewood, and so we needed a place to store it. So we were storing firewood at this location, and we've been doing that for over 5 years now. We've donated firewood to the people behind us that have no heat and come to me and say, we have no heat, and we support them by giving them free firewood. We have City of Sandy Springs the last 3 years. We've donated firewood for a few of their bonfire events. We actually even have some Cobb County engineers that rent space from me at the chiropractic office. David Baggett and some of the engineers are actually there, and several of those guys get firewood from us also. About a year ago, Officer Foster, who was very nice, by the way, so I second what the young lady said at the beginning this morning about how nice she is, was great, and Margie's been very nice, and also I even talked to Mr. Peterson on the phone, also very nice, and I even met with Miss Richardson. Officer Foster came to me because I had a firewood company that had dropped off some oak firewood, and they left it on the right-of-way, and I had no idea that it was on the right-of-way. So someone had complained that there was tree trunks on the right-of-way. Miss Foster came out and gave me a citation for trees on the right-of-way. I proceeded to tell my wife and got yelled at by my wife because she told me for years, why don't you just put up a fence and then no one will bother you? And I never did, and now I'm even in more trouble with my wife for being here today. So I got the citation. Officer Foster was very nice, tried to work with me. She said, well, you got to have a special land use permit for all of this firewood. And so I went down to the Cobb County office, and the guy said, well, you can't apply for a special land use permit because your building is zoned office because I have a chiropractic office there. And I said, well, I'm caught. And he said, well, you're just going to have to rezone it. And I said, I can't rezone it. That's where my chiropractic office is. So I couldn't rezone it. So then I went and had a meeting with Commissioner Richardson and her staff. She was great. And she came up with the idea of, why don't you apply for a temporary land use permit? And that will give you 2 years, at least 2 years, to keep your firewood there, clean up everything, and then maybe figure out another spot, whether you buy another spot in Cobb County, whether you extend it after that, whether you form a nonprofit. So that's where I'm at now, is I'm kind of caught because I have all of this firewood and I can't necessarily just scoop it up and get rid of it. We are trying, and we're trying to clean it up. So I did want to, but I will tell you a couple things. We have no on-site sales. We have no street parking. We have no signs. It is a chiropractic office, but I did want to show you. Do you mind putting that picture up? So that's kind of a before picture of if you're driving down that back road, what you would see. But what my plan is to do is to put up a fence that looks like this, which would be after. So if you're driving down the road, you'd see that. My other plan is, if it appeases you guys, that we would never go above that 6-foot fence. So no one would ever see any firewood from the road as they're driving by. I'm trying to think of what else. No signs, no on-street parking, no on-site sales, and that's all I have. I know it's been a long day and I don't want to waste any more time. So I'm hoping that I can store firewood there for the next couple years and continue to raise my boys and get them to continue to split firewood with me and grow big and strong and be good members of the community.
Thank you.
Yes, sir.
Thank you so much. There was no opposition, correct? Awesome. So this is also in District 2, so I'll turn it over to Commissioner Anderson for our discussion.
Thank you. Yes, Dr. Cobb.
I'm sorry, I forgot to say one thing. And I did get approval from the 3 hotels that are near me that said they had no problem with me with the firewood storage, if you want to put that on there too. I'm sorry to interrupt, I apologize.
No need to. Thank you very much, Dr. Cobb. Appreciate it. The only question that I had, and I have a couple questions of staff, but the only one would be just, have there been other alternative locations you've explored nearby? What's that process looked like, and
We've just started. We've just started looking for other locations where we could store the firewood, but it's very difficult to try to find a location with the proper zoning already. So I don't know whether I would have to buy a property and then try to, I guess the perfect thing would be to get a Cobb County map that says all of these places are zoned where you could store firewood, and then I could directly go contact those people and see if there's any interest in selling them.
Got it. That's a really helpful bit of information to know, so thank you very much.
Yes, sir.
I do have a question of John Peterson. Oh, you know what? I apologize. I didn't ask if anyone else had any questions, any other of my fellow commissioners had any questions of the applicant.
Any questions for the applicant from commissioners? Yeah, one.
My apologies again on that oversight.
Oh, no problem. Thank you very much, Commissioner Anderson and the chair. I saw the picture of the proposed fence, right?
I'm sorry, of the fence?
I saw a picture of a fence.
Yes, sir.
That's a proposed fence as opposed to existing, or?
So what I did is, in my cleanup of the property, I actually fenced half of the, well, not half, a third of the property already, and that's just a picture from the road. I'll show you. So as you're looking at the property on the right side, I already fenced that in. But the left side, that the picture I showed you of the firewood, is not fenced in yet because that's about a $7,000 estimate. And I didn't want to fence it in unless I didn't want to spend the $7,000 for a fence if I was going to get denied of having my firewood storage there for the next 2 years.
So my other question was, would it be possible to move that fence back some off the road?
Yes, sir.
Thank you.
And I can put in landscaping, make it look as nice as possible, and I won't have the firewood go above the fence.
Thank you. I think you can have a seat. We're done.
Not so much a question, but just a comment too. And I think the gentleman just alluded to it. Landscaping along the fence, I think, would be appropriate as well. So however you want to handle that.
Okay. Great. Thank you, Commissioner Hughes. Mr. Peterson, just a quick question for you. For land use permits, are there any categories where a use like this is considered acceptable as of right? Are any other categories that you would know of?
There are no land use permits that are used by right. A land use permit allows you to do something in a zoning district that's not normally permitted.
Okay. So in this case, is there any prohibition? It sounds like then there's no, any LUP used in anywhere where a LUP can be applied for would allow, assuming approval, this use, subject to the conditions laid out?
Well, it's subject to approval by the Board of Commissioners.
Okay. So it's not necessarily category specific?
That's right.
Okay. Are there any natural guidelines that planning staff look at in terms of considering storage?
Well, this is
usage?
the first one of these we've had for this type of use. And I think with the applicants, discussions with staff and some other folks, it was decided that if he went in this direction, he would have to put up fencing, come up with guidelines for where he's going to store it, signage and things like that, just to kind of hide it from public view.
Got it. Okay. Great.
Can I ask a question real quick? I'm
yes,
sorry.
Please. Any other?
I guess to get it, maybe, I don't know if this is what you're getting at. Is there another zoning category where this would be permissible? LI, HI?
It'd have to be heavy industrial.
Okay.
I'm sorry, you said heavy industrial?
Correct.
Heavy industrial, okay. And in that instance, that would not require or would require still a land use permit within heavy industrial, or would that be permitted just as a permitted
It
use?
would be permitted just for the storage of the firewood.
Okay.
If he's storing it only.
Okay.
So I think to address a comment I think I heard the applicant make about having a map of the county, maybe a map that shows all the heavy industrial areas could help focus his future search for property. Just a comment.
Yep. No, it's a great comment where I'm heading here. Are there any other questions of John by by my fellow commissioners?
Or question of any other staff?
Other staff, okay.
Back to you.
Great. So I think I'm prepared to make a motion here that we hold this for 60 days with guidance to the applicant to work with community development staff to identify proximate sites within suitable categories, zoning categories that could be alternative locations. That's one. Number two would be for the applicant to craft or develop a site plan that reflects landscaping and any fencing that could conceptually be programmed here and submit that for review by the staff. I think that would be helpful for us to understand if there aren't any nearby alternative or suitable locations, what is the plan for actually storing this and properly shielding it from view? So my motion again would be to hold for 60 days. And the guidance to coordinate with staff on the identification of suitable sites, alternative sites, and development of a site plan in the case that the use remains on site.
We have a motion on the table. Is there a second?
Second.
Okay. We have a second.
question.
Let's open for discussion. Yes.
Okay, is it your intention that the hold for 60 days is at the end of that time, the applicant is going to bring it back here to be heard by this board?
That would be my intention.
Okay.
Although that would only apply if it was happening, if there was a need, in the case of an off-site solution being found.
Then he could withdraw, correct?
Right, you withdraw, or.
But right now, in the present moment, the intention is that we're going to hold for 60 days with the intention that the applicant bring it back in 60 days and work with staff in the intermediate period. Is that clear?
Yeah, that's correct.
All right, thank you.
Yes, Commissioner.
Further discussion? Let me raise one point. So it's a holding for 60 days, and in that time, I just want to make sure I understand your motion. He's going to look for new space or alternative sites, correct?
Yeah, suitable locations. Working with staff to identify those.
Okay.
And that gives opportunity to actually see if those locations are available. There may be a need to come in and request another extension at that point.
And so
If not,
my question for my fellow commissioners is he's applying for a temporary land use right now. So what's the incentive for the land use permit if we're not granting a temporary land use permit, if that makes sense, my question? Because this is a 2-year temporary land use, but we're saying we're going to hold on deciding on temporary land use to give him time to do a permanent solution, which my understanding, that's what the temporary land use is for, to allow for that. Am I missing something? But
yeah,
I'd love for everybody to weigh in on that.
I'm happy to reply after.
Yes, staff, Mr. Peterson.
And there's just one thing, in my notes I have, make a site plan of what he's going to do with the fencing and the storage area. And the second one is a map or a list of suitable sites that he could do his business on. The staff can definitely make a map all day long of where the HI and LI in the county is. But, what we can't do is act as a broker or give them advice on what to buy and what can't to buy, what not to buy.
And just to reply, so my understanding is that since there is a code enforcement associated with this, that there's a timing that basically allows, this code enforcement does not actually get triggered by action but until there's a resolution on this land use permit. But the expectation is that this site as it is today is not suitable for this use. There would be some amount of time needed to actually identify suitable sites, and there's probably a bias towards having it be programmed off-site. That said, that doesn't happen overnight, and this allows for a time for that code enforcement action to not be triggered while giving a small period and window during which those suitable off-site solutions could be identified, because this by itself, absent a site plan that shows landscaping, fencing, actual demarcation of locations, doesn't read as though something where it would be a suitable land use permit.
It just seems to me that if we're going to make them do a plan that shows landscaping, fencing, and everything else, that maybe we shouldn't be pushing them away from the site if we're going to require this plan that's never going to happen. That's my only concern.
That's some of my questioning, which I was leading to. If we're going to put had stipulations around fencing or landscaping, would we not grant the temporary land use for 2 years while still encouraging a more permanent solution? Because if not, for 60 days, I don't know if I can agree to stipulations around landscaping if it's a 60-day solution.
Or would you consider granting it for a year to allow for that opportunity?
And just to be clear, my stipulation wasn't to actually dictate parameters of a landscaping plan or of a site plan. It was to provide a plan that has those parameters at least noted on it. So I think the stipulation is we have a site plan from, I think, 1990s in the current packet. But to the extent that there is something programmed on site, at a minimum, I'd like to see, without advertising or putting out any landscaping buffer requirements or anything related to that, or any conditions, just see a new plan.
But does that 60-day waiting period and just a plan answer the question from code enforcement? Like, that doesn't answer code enforcement concerns or questions for the 60 days, correct?
Right, but it does withhold an action of code enforcement and gives them the applicant time to find an alternative solution without the code enforcement action actually taking effect.
Yeah, and Chairman Vaught, what Mr. Anderson is saying is correct. You know, when he's going through this process, through the land use permit process, all the code enforcement actions are stopped until there's a final resolution by the Board of Commissioners.
Perfect. Right. Thank you for that clarification.
I think what Commissioner Anderson's trying to get to is he's encouraging option A instead of option B, but would consider option B if necessary. Is that?
I think that's a fair statement.
Okay. Thank you.
But I don't understand that one.
Preferences for off-site. I think that makes more sense for this. But I think knowing that that doesn't happen overnight, identification, giving the applicant time to have the opportunity to identify these could be useful. And I don't know, I think the applicant wanted to answer the question, but I don't know, the county attorney I don't know if the public period is still open for.
Yeah, I don't.
You can certainly call someone back up to answer questions if you want, before a vote is made.
Dr. Coleman, we'll call you back up to ask some questions.
Yeah, sure. So.
I appreciate what you've done to give me the 60 days, but I understand where you're coming from also. So could we possibly, I don't know if I'm out of line, I apologize if I am, do a combination of both, which is, because I still have to go home to my wife. And if I have to tell her we have to buy a place in 60 days, she's gonna freak out on me. So can I have may I have, I would be willing to put up the $7,000 fence. I would be willing to do the landscaping, make it all look pretty from the view, not keep the wood, not allow the wood to go over the 6-foot fence for the 2 years, but that gives me time to still work with Mr. Peterson on trying to find a possible place, maybe a combination of the two, if that helps at all. I think 60 days is, I just don't want to waste your time, come back in 60 days and go, I have no idea. I'd rather just spend the money on the fence and the landscaping and give me the opportunity over 2 years.
Thank you, Dr. Coleman.
Yes,
we
sir,
appreciate that comment. I think that goes back to my questioning. My questioning is a 60-day hold. That doesn't give you enough time to find the property buyer. I mean, I'm concerned about the constraints we're putting around this, and that's for me, you come for a temporary land use permit to do these types of things, and so I'm still confused by a 60-day hold on a temporary land use permit.
Maybe Commissioner Dance said this earlier, maybe it's a 1-year temporary, so there's some sense of urgency to go ahead and look for property, and you have time to identify it, have time to hopefully purchase it, close on a transaction, if necessary. So.
Yeah, I'm open to 1 year, and by no means am I implying that there's a need to purchase a property as opposed to finding a space to locate your wood as you pursue a more permanent solution. And that was really kind of where the timing was. But I think that given the input from the commissioners here, I'm supportive of a 1 year. This would be effectively a motion for a one-year land use permit. But the question, I guess the initial motion was to hold.
Yeah.
Is there an alternative motion then that would help
We
construct
can
this?
make an alternative motion, but I now have a question to staff.
Okay, first thing we need to do is withdraw his original motion. So we just need to, you have you withdraw it. Okay. Was there a second to it?
I'll make a motion to withdraw my original motion.
I think Commissioner Dance seconded.
Oh.
So you'd have to remove the second.
I second.
And so,
New motion.
new motion, yes. So you making a new motion?
I would ask for, prior to doing so, just to confirm, the desire is to actually approve a land use permit for a 12-month period.
Subject, and we're just having a discussion, right?
Yep. Yes. I'm just making sure I'm capturing everybody's
Okay.
input.
Well, I think you're approving the land use permit. You're accepting the conditions he's willing to put on it.
Yep.
You're going to put those conditions on
Right.
it for a one-year time period, and you're going to encourage him in the interim period to seek a permanent solution.
Okay. That works. That works. Okay, so I think we got it. I'll find a new way to mess it up, trust me. But first of all, is there any other discussion?
No.
Okay. So I'd like to make a motion for approval of a 12-month land use permit, subject to the applicant installing a fence surrounding the perimeter of the site that currently is occupied by storage, firewood, a landscaping in front of that fence of sufficient height to, I'd say, a minimum of 6 feet. Yeah, I'd say, so those would be the two conditions. The only question I would have of my fellow commissioners is that height threshold sufficient in your mind, or is there any specifics you want to put around that? If not, we can consider it left at that.
Well, he further agreed that he wouldn't allow what was stored behind the fence to exceed the fence height.
Okay.
Right? Yeah.
All right.
That's what I was going to say.
So the third condition would be a prohibition on storage height of firewood exceeding the height of the greater of the landscaping or fencing buffers heights. And with I guess the fourth step would be encouragement of the applicant to pursue a off-site solution during this time period.
We have a motion by Commissioner Anderson. Do I have a second? Second by Commissioner Dance. Is there discussion or further discussion on this? If not, let's call the question. Okay, by a vote of 5-0, we recommend approval of LUP 5 with the associated stipulations. All right, thanks.
Okay, last thing on the agenda is to consider your other business item, which is to consider amendments to Chapter 134 of the Official Code of Cobb County. And I believe Jessica Gwynn's going to deliver that to you virtually today.
Okay, Mr. Peterson, can we move to take a break before we hear our amendments? So let's adjourn for 5 minutes and then proceed. Thank you. Thank you, and welcome back as we try to wrap up this meeting, and we have other business case. So, Mr. Peterson, if you could reread that into.
Okay, the first and only other business case today is to consider amendments to Chapter 134 of the Official Code of Cobb County, and Jessica Gwynn's going to present the revisions that y'all heard last month regarding the changes to the zoning code.
So last month, or at our last meeting, Jessica did take us through a presentation that walked us through the different amendments to Chapter 134 of the Official Code. We then allowed an open period where the community could make comments, and we gave them each 3 minutes, I believe, to talk. Are there anyone here today to speak to those open amendment items? We have one. Can she be sworn in so we can allow 3 minutes for community comment?
Yeah, we have one virtual, one in person, and we probably should hear Jessica give the update before we have the input.
Is Jessica on the phone?
Yes.
I'm sorry, I didn't realize that's just what you were saying. So yeah, let's start there. And if Jessica, if you could take us through the presentation on the amendment and what's open.
Yes, good afternoon, Planning Commissioners. Jessica Gwynn, Cobb County Community Development. As you'll recall, there were 4 code sections that you all continued over to this month, and so I'll hit those really quickly. It was really pertaining to 2 main topics, the first being the traffic study requirement, and the second being requirements for freestanding climate-controlled self-service storage facilities. And we did have some good public comments on both of those items. Last week on Friday, I sent you the latest and greatest drafts of those documents, and we've worked closely with DOT staff on the DOT component, and also had a good meeting out in the Northwest Cobb area with Commissioner Gamble and some of the residents who spoke at the last Planning Commission meeting regarding the self-storage facilities. So I'll just hit the highlights, and we'll start with 134-121, and of course that's the piece that pertains to the requirement for a traffic study on rezoning applications and land use permit applications. And Amy Diaz is also on the line, so if there's any detailed questions regarding this one, then I may defer to her because this was primarily put together by DOT. But some of the things that came out of that, at the last meeting, there was some discussion about the number of vehicle trips that would necessitate a traffic study. As you'll recall, under the current code, 75 single-family homes would necessitate a traffic study, and the proposed amendment actually modifies it so that it's based on trips versus the number of units. And that's important because the number of units, or the number of the square footage that you have, especially on some commercial and industrial properties, is going to vary in terms of the types of vehicular traffic it's going to generate. For instance, a 25,000 square foot self-storage facility or storage building is not going to generate the same degree of traffic as a 25,000 square foot store would. So it's appropriate to look at those differences there and to base it on the trip generation. So at the last meeting, we talked about reducing that from 1,000 vehicle trips per single day to 750, and you'll see that reflected in the draft that I sent to you last Friday. And also that would equate to 75 trips per hour rather than 100. And one important point that was raised through that discussion was differentiating between vehicle trips and trip-ins. So to clear that up, DOT has eliminated the language that previously said vehicle trip-ins and specified as just vehicle trips. So you'll see that language to change to reflect vehicle trips versus trip-ins. Most of the changes, a lot of the changes in this, and forgive me, I'm looking at it on my other screen here, but a lot of the changes in there is just reordering of where the language was in other pieces of, or in this section of the code. So the most significant change there is really pertaining to the number and then specifying vehicle trips versus trip-ins. There's also some language in here. There was a lot of comment about when project-related improvements should be made versus contributions, and there's some language in here that speaks to that also and just clarifies that if the applicant is going to provide mitigation measures for project-related transportation improvements. Those that are identified by DOT, those funds, anything that would be contributed there would be limited to addressing the problems created by the project. In addition to this, so that's the change to 134, 121, but one thing that is important to this is that there are some definitions that would also be incorporated. So 4 definitions that would go into section 134-1. The first one being a definition for travel mode, the second one being definition of trip, the third trip generation, and the fourth trip generation rate. So those are definitions that have been incorporated to really clarify what we mean whenever we say vehicle trips and to make sure that it's very clear from now in perpetuity. At this point, section 134-1 is not before the Planning Commission for consideration. You all moved that forward in January. So if you move this one forward, we would ask that you move the changes, the amendments to 134-121 forward with a recommendation to add these 4 additional definitions to 134-1. And that one is still open before the Board of Commissioners, so we can still make that change because it's already been advertised for amendments for 134-1. And that'll be heard next week at the February 8th Board of Commissioners meeting. The second item, the self-storage facilities, as you'll recall, what was proposed was to eliminate Code Section 134-279, which currently speaks to these facilities. Currently, in the LI light industrial and also HI heavy industrial districts, these facilities, the self-storage facilities, are permitted by right. So as long as there are no variances required, someone could come in on one of these properties and establish one of these facilities without having any consideration by this board or by the Board of Commissioners. So what's been proposed is to eliminate 134-279 and to incorporate the standards for these facilities into the light industrial and heavy industrial district regulations, similar to how they are in the office and institutional and also the NRC districts. So it's the same language that you've seen reflected there, and that's what we put forth initially. We had a great meeting with a lot of folks out in Ackworth areas I mentioned before, and Commissioner Gambrill, and to hear some of their concerns. I know they've got one property there they're particularly concerned about. It's a property that's spot zoned heavy industrial and in really a pretty residential area, or what's developed into a pretty residential area. And so in hearing those concerns, I want to walk through the changes that we proposed. And these changes apply to both Section 230, the light industrial, as well as 231, the heavy industrial. So it'll be the same language in both code sections. The first is with regard to height, and we heard that there was a lot of concern there about height. And the way that the code is written as proposed, any of these facilities in light industrial or heavy industrial would have to come in and get a SLUP. They would no longer be permitted by right. So they would require consideration by the Planning Commission and the Board of Commissioners regardless. And we put in there that the height should not exceed the existing adjacent buildings or impact the view shed. What we added in there to bring some of the requirements of 279 over and sort of clarify this is that the maximum height of a freestanding facility shall be no more than 20 feet above the finished grade, unless approved by the Board of Commissioners. So that does give some, hopefully a degree of comfort to the residents in the area that there is that maximum height that's allowable without having approval by the Board of Commissioners. Again, Board of Commissioners has to approve this regardless because it would be a SLUP process, which it is not currently. We also, on item 2, added some clarification that FAR shall not exceed 1.0. Previously, it just said should be, so we clarify shall not exceed, and I think that's appropriate. Moving on down to number 7, which speaks to the storage of recreational vehicles. We've incorporated some of the language that was in 279 to beef this up a little bit to say such storage shall take place only within a designated area on a site plan approved by the Board of Commissioners. So if people are storing boats or RVs or what have you, they would have to identify on their SLUP application and their site plan where that storage would take place. They would have to be stored within an area that is outside the minimum building setbacks as well. And then moving down to number 11, 11 speaks to landscaping plan, and currently it says, or in the first draft, it says the landscape plan has to be approved by staff with an emphasis on planning with the parking facilities. Again, we've pulled some of the language from the 279 over to enhance that language a bit to say a landscape strip of at least 20 feet in width shall be provided along all street frontages. If the existing vegetation is inadequate to buffer adjoining residential development, additional plantings or 6-foot wooden fence shall be installed to provide visual screening year-round. So again, just enhancing that language. And number 13, this speaks to the loading area. And one of the things that was in there was that the loading area should include adequate turnaround space for a tractor trailer vehicle. The property that the neighbors we met with were most concerned about is actually a property that's on a local road and really isn't conducive to tractor trailer traffic. So we wanted to ensure in here that if the access to this facility is not from a road that is designed to handle that type of vehicle, that, you know, those would be excluded. So we've added in here that facilities accessed by a major thoroughfare, arterial major collector, or minor collector would have to provide that adequate turnaround space for a tractor trailer. But then we also added that no tractor trailer vehicle access shall be permitted from local roads to clarify that further and protect those local roads from that type of traffic. 14 speaks to lighting. Previously, it just said that the lighting plan would need to be approved by the Board of Commissioners. Again, we pulled over, it would still need to be approved by the Board of Commissioners, but we pulled over some additional language that was included in 279 to say that all outdoor lights shall be shielded to ensure that the light and glare are limited to the premises and directed away from adjacent properties, and that outdoor lighting adjacent to residential property would need to be limited to a maximum of height of 15 feet. And then the final change is in number 17, which speaks to hours of operations. And of course, the way that the code was previously written, or that the draft that's been put forward initially, states that the hours of operation would be established by the Board of Commissioners, considering the operational hours of surrounding businesses. Well, in some cases, like this particular site, there may not be surrounding businesses that are immediately adjacent. So we've included in here surrounding uses that we should take into account, or the Board of Commissioners should take into consideration surrounding uses and be sure that the hours of operation are appropriate based on those. So again, all of that language is incorporated in both 134-230 as well as 134-231, and we still are maintaining that in changing these code sections, we would then remove code section 134-279. So I'm glad to answer any questions, and again, just appreciate the input that we've had from the citizens who have shared their comments and their feedback on both of these sections with us.
Awesome. Thank you so much, Jessica. Okay, now we will turn it to, are there any questions for Jessica from any of the commissioners? I'm sorry. This one?
Yes,
Commissioner Balloon.
But I might prefer to wait to hear what the public concerns are before addressing those. Thank you.
Okay, let's hear from the community. We are allowing 3 minutes for comments from the community. I know we have one in person. Is there one online as well? Okay, let's start with in person. If you'll come up to the mic and state your name, and then you'll have 3 minutes to address the body.
Good afternoon. Teresa Stendal, residing at 5850 Autry Church Road, Ackworth, for the last 47 years. As a follow-up to comments previously before this board, we do appreciate the time that Ms. Ginn and Mr. Peterson took to come out there. We did have several of us, and I don't live on Rutledge, let's be clear about that, but I live in close proximity, as does several of the other attendees, but we had 2 from Rutledge, and also Mr. Ken Horton, owner of the Governor's Club. And while I do think we're going in the right direction, and I do think that what community development has incorporated has been a positive, I think the timing of all of this happening with the revisions that we only received on Friday has just not provided enough time for it to be fully vetted by those who have the most interest and the potential impact to what these changes could be. And I think particularly bothersome is that when you're deleting an entire section of the code that really qualifies everything regarding height, this particular parcel that we have been the most concerned about is on a 40-foot slope. So when you talk about a 20-foot from finished grade, it depends on where that finished grade is, because currently Rutledge Drive sits higher than Cobb Parkway. So it's still very open to interpretation. I think it can be very subjective. And yet everything on that street outside of this one parcel of land is a residentially, developed parcel of land, and it's R30. So with that, while we do appreciate the efforts that have been made thus far, my personal opinion is that there is more time needed, and we need to make sure that we get it right before we start deleting code sections and replacing it with substitutions, while on the surface look to be a benefit and a protection to the residential area. I'm just not quite there yet. Thank you.
Thank you.
I would ask that you withdraw this from the packet for further work and consideration between community development and us.
Thank you. And now we have community comment on virtually.
Yes. We have Mr. Greg Lowry. Mr. Lowry.
Hi, this is Greg Lowry. Can you hear me?
Yes, we can. Go ahead, Mr. Lowry.
All right. So I do live off of Rutledge Road. I've lived here 20 years on Gwendolyn Court. And yeah, I appreciate the chance to meet with Jessica and John last week. Same situation. We have received some language change in the code that they have proposed. And, it's, if we could take the best of what's in 279 and maybe blend it with what they're proposing in 134, 230, and 134, 231, that would be helpful. But I'm very concerned that the new code really opens up some things some limitations that are currently available that protect us. A height limit being one of them. That's a major concern. It's just not at a point, I think, that really protects us and gives us a whole lot of comfort. I'd like to continue to work on it, but the version that I saw last Friday still hasn't been agreed on, and it's just, at this point, not something that I would agree with. So I'd like to see this either held further or removed from the package. Glad to keep talking about it and glad to keep working on it, but if it goes through in the form it's at now, it would apply to any HILI parcel, and that would be county-wide, and that would really open up a lot more options for the developer and less options for the community to oppose. So that's my comment. I'd like to see it either held or removed, 230 and 231 held or removed. That's all.
Thank you, Mr. Lowry. Is that all for community comment? Okay. Thank you to everyone who shared their comments with us today. I'm now going to open it up for questions to my fellow commissioners. If you have questions of staff or want to inquire more from any of our community commenters.
Thank you very much. So for Jessica, just reading through here quickly, hopefully I have the right piece of paper in front of me, but it says not addressed in 134-279, lighting plans to be approved by the Board of Commissioners, limited to a maximum height of 15 feet. Would that be 15 feet from the grade of the building?
That would be 15 feet from the ground, 15 feet high light poles, or, right.
All right, from the grade of the parking lot?
From the grade, yes.
Okay. As to the access questions, there's a provision that says, at least, hopefully I'm looking at the right piece of paper, 134-279 requires a self-service storage facility shall be located on a lot that gains access to a local non-residential major collector or arterial street as defined in the major thoroughfare plan. Hopefully I'm reading the right thing.
I think, you're looking at 279. I think you may be looking at the comparison document perhaps that was put together.
Yes.
Okay.
Okay. So is this part of what you're proposing or not that I'm looking at here?
What you should be looking at is what I sent you Friday.
Okay.
And it's got, that document has, it's a Word document, it's done in track changes format, so you can see the changes that have been made since the last meeting. And on that document,
Has the
the
little number
language-
3, has the little number 3 in the upper right?
Yes,
that's it.
yes.
That's it.
Okay, good, thanks. Okay, so did either of the comments I just have, are they even addressed in here? The gains access document, or gains access issue, is that even addressed in here?
The lighting is in there. The access is number 13.
Okay.
Let's see here. It speaks to. Okay, so there's number 3 speaks to all units shall be accessed from a main or central entrance. And then whenever you scroll down, number 13 speaks to if facilities are accessed by a major thoroughfare, arterial, major collector, minor collector, then they need to provide adequate turnaround space for a tractor trailer. And that if they are accessed from local roads, then tractor trailer access would be prohibited.
Okay. How are we effectively going to stop a tractor trailer from pulling into a local road, just pulling alongside the shoulder of the road and basically carting stuff into the property?
I mean, that would be, and as I understand it, on the particular side over there at Rutledge, they have some issues with vehicles that shouldn't be turning into there. So I think that's something that perhaps DOT may want to look at, signage for that road. Again, I would maybe look to Amy to address that, how DOT could address it, because it sounds like that's a problem that may be happening already regardless of self-storage facility. So for properties that were accessed on local road, there would be about signage and you know, designing it in such a way that a tractor trailer would not be able to turn in there and to be accommodated.
Most of the self-storage I'm familiar with are on fairly major thoroughfares in the county, like on Dallas Highway or Highway 41, right?
Mm-hmm.
Is that fair? I guess there's some on Canton Road that I've seen, or I know some down around in the Cumberland area, but are very many of our self-storage right now on local roads?
And that's a great question. I will say, you know, and Mr. Lowry made a great point. You know, this is an ordinance that's not just specific to one property. It's specific to, you know, it's countywide. It's got countywide implications. And yes, typically those types of facilities are going to not be on your one way or dead end residential streets. In the case of the one that the property that they've been speaking to, that's very unusual, and that's why it was important to include in here a prohibition that in the event that one of those facilities is located on such a road, then there should not be tractor trailer access. And the other thing I'd like to point out here is that that property currently is zoned industrial. So the additional protection that this provides is, as it sits right now, this type of facility is permitted by right. As it sits right now, if we brought this in, if this code amendment is approved to require a special land use permit, then regardless of the fact that it's already been zoned industrial for years, it would have to come to the Planning Commission as well as to the Board of Commissioners to be reviewed and approved through a SLUP process. And that gives your board as well as the Board of Commissioners and staff the opportunity to look at the unique features of the property, such as this property that happens to be on a local residential street, to give staff and the Planning Commission the opportunity to take that into consideration, ensure that the stipulations that are placed on that are appropriate for a facility like that to be on that type of property.
Except the way it's written right now, they would have to come in for a permit to go above 1 story, correct? Is that
Under the current code, right, under the current code, they would only have to come get a SLUP if they wanted to go above 1 story, 20 feet in height.
Okay, and the understanding here and going to 20 feet is, would 20 feet be a standard height for a 2-story? Is that the expectation?
No, you know, the expectation is in saying 20 feet, and we can make it say 1 story or 20 feet. If you have a 20-foot building, it could be 2 stories. That would be very low ceilings, but what we don't want to have is a 1-story building. That's a 1-story building, but it's towering. You could also have a 30-foot tall 1-story building, as you know. So if there was interest on the Planning Commission, and it may give some degree of comfort to say 1 story or 20 feet in height, or 1 story not to exceed 20 feet in height, then that's certainly some language that we can include in there to clarify it.
Okay. And then let's go back to the, is there something in here somewhere about the road access? It's supposed to be a certain type of road access? You were pointing me to
Right, and 13, item number 13, it doesn't say that you can't have it on any certain type of road or that it's required to be on any certain type of road, but it does say that if it's going to be on a local road, then you wouldn't be able to have tractor trailer access. And I would believe, I'm scrolling through the code right now, I believe that currently the code does not provide any prohibition on these types of facilities being on local roads. So again, this would give some additional protection there to at least ensure that if it's going to be on a local road, that it would not be able to provide tractor trailer access, that would be prohibited.
And I guess my other concern, just thinking back about that one case, I had a concern with folks, not as concerned about folks pulling in an SUV, more concerned about folks maybe pulling a boat around on the back end of their SUV and pulling it onto a local road. Is there any, there's nothing in the code here to provide any specific protection as to those sort of things?
No, but again, that's a unique circumstance that doesn't apply to the majority of properties where this type of facility would go. So that's exactly the type of thing that you want to look at specific to the site in question. What are the unique circumstances where there may be some stipulations or some conditions that are appropriate to apply based on those unique factors that don't apply countywide?
Would there be a way to make the change to 1 story instead of 20 feet in paragraph 1, but then add some other provision regarding allowing for a potential change in height higher by land use permit? Would that still work?
The code right now, but the language that we have right now says the maximum height of a freestanding facility shall be 20 feet above the finished grade unless approved by the Board of Commissioners. So maybe what we do is we say the maximum height shall be 1 story, not to exceed 20 feet above the finished grade unless approved by the Board of Commissioners. So we can add in there 1 story if that clarifies it further.
Okay.
And it would still require approval if they wanted to go higher.
Okay. Well, thank you for all your constructive efforts here. I appreciate it. Thanks for answering all my questions. There's no court reporter, but I'm sorry to put you through that.
Jessica, while we have you, let me open it up and make sure any other commissioners have questions around the proposed amendment changes for Jessica. All right, thank you. I'm sorry, we've heard discussion and heard community comments. I know we have voted on approval for other areas of this, but as Jessica presented, we still have these two open, 134-121 and then 134-230 and 134-231. So I will entertain a motion from any of my fellow commissioners at this time.
I'll try it. I'll move that we recommend the approval of the proposed sections 134-230, 134-231 with the change just suggested to add to paragraph 1 of each a limitation of 1 story not to exceed 20 feet in height unless approved by the Board of Commissioners.
Will you also, as part of the same motion, add in 134-121 on traffic study?
Yes.
We had you addressed the other ones, but
well, do we want those, counsel? Before I make that, do we want those separate, or do you want them? The clerk's nodding.
Clerk said separate.
Separate. That's how we did it.
Okay.
Last month.
Well, then let's back up and take them in order. Let's start with the traffic study 134-121, and we heard Jessica's basically give us what we had asked for in our last meeting, where we talked about trip ins versus vehicle trips or total vehicle trips, and she gave us that clarification. So now I'll pause and take any motion from any of my fellow commissioners regarding 134-121 and the amendment related to traffic studies.
Motion to approve section 134 dot 121 as revised.
Okay, we have a motion from Commissioner Hughes. Do I have a second?
Mr. Chair,
Yes.
just a quick point. I would ask that the Planning Commission's desire is to move that forward, that the motion be to recommend approval of 134, 121, but to recommend also the incorporation of
Oh, I'm
those
sorry.
four definitions into 134-1.
I did have it. Thank you, Jessica. And that motion would need to include the addition of the four recommended definitions, which would fall into 134-1.
So let me amend my motion to recommend approval of 134, 121, and to recommend approval of 134-1 definitions.
Perfect.
Second.
Second from Chairman Ballon.
Oh, I'm not the chairman.
I mean, Commissioner Ballon. Still kind of chairman.
Can I ask a question?
Yes, discussion.
So, I mean, Jessica, these are still under consideration and are still being shaped because this is just a public hearing for input, correct? So.
Yes, ma'am.
Okay, so if we're recommending it, we're recommending further consideration of it consistent with what's been done so far, is that right?
Well, it sounds like
Yes.
definitions were still open, right, Jessica?
Right, the definitions, 134-1 has already been moved forward by the Planning Commission.
Okay.
So it's not something currently under your consideration right now, but the Board of Commissioners does still have 134-1 open for amendments until the next second public hearing on that chapter is on next Tuesday. So in consulting with the county attorney's office, I was advised that this would be an appropriate way to move this forward and ensure those get included.
Okay.
So, Michael, if I could just ask you, could you clarify your motion as to whether or not you're recommending specific language or whether you're recommending moving these items forward?
I'm recommending moving these items forward as presented today. Does that?
Jessica, does that make sense?
Yes, ma'am.
Okay.
Until your second still holds. Okay, any further discussion on this? If not, let's call the question on 134-121. By a vote of 5-0, we are recommending moving forward with 134-121 on traffic studies requirement on rezoning applications. Now, we'll move to 134-230. And can we take 134, 230, and 231 together, or you want them to be separate? 134, 230, and 134, 231. Since the language is all the same.
Just go ahead and take them separately.
Okay.
Even though it's the same section, but
Okay.
that way it's just cleaner even for our minutes and as we make the recommendations up to the Board of Commissioners.
Got it. So let's take the first one, 134-230, as it relates to self-storage facilities and light industrial for 230.
Mr. Chairman, since you looked at me, I'll take that as recognition. Thank you. So the motion is to recommend approval of this revised section 134-230 light industrial district as written, with the one change to paragraph 1 to change the height, the maximum height requirement to read shall be 1 story, not to exceed 20 feet above the finished grade unless approved by the Board of Commissioners.
Okay, we have a motion by Commissioner Ballon. Do I have a second?
Second.
Second by Commissioner Hughes. Any discussion? Not, let's call the question. Okay, thank you. A vote of 5-0. We are recommending moving forward with 134-230 self-storage facilities as it relates to light industrial. We will take the next one up, which is 134-231 self-storage facilities in high industrial.
And my motion-
heavy industrial, excuse me.
My motion, Mr. Chairman, would be also for approval of the revised section 134-231 as written, with the exception of a change to paragraph 1 to provide that the maximum height of the freestanding climate self-controlled storage facility shall be 1 story and shall not exceed 20 feet above the finished grade unless approved by the Board of Commissioners.
We have a motion. Do I have a second?
Second.
Second by Commissioner Hughes. Any discussion? If not, let's call the question. This is also approved by a vote of 5-0 to move forward with 134-231.
And Chair, we also need a vote on 134-279, the deletion of that section.
Got it. I had that on here. So we also need to 134-279, which was that original section, which this 134-230 and 134-231 are now going to address. So do I have a motion to recommend deletion of 134-279?
So moved.
And do I have a second?
Second.
Seconded by Commissioner Hughes. Any discussion? Let's call the question. So by a vote of 4-1, with Commissioner Dant voting no, we vote to move forward with deletion of 134, or recommend deletion of 134-279. If that is it on other business, we will go into our approval of our minutes. So we have a couple of, you should have all of this in front of you, but we have minutes from our December 7th Cobb County Planning Commission.
Move to approve our minutes from the December 7th, 2021 zoning hearing.
Do I have a second?
Second.
Second by Commissioner Anderson. Call the question. Okay. Minutes are approved by a vote of 5-0 to approve the minutes of the December 7th Planning Commission meeting. Next, we have the January 4th, 22 minutes of the special call meeting and agenda review work session. I have a motion to approve those minutes.
So moved.
And second?
Second?
Second by Commissioner Dant. Let's call a question. Approved by a vote of 5-0 to approve those minutes. We have quite a few here. So the January 4th, 22, 7 p.m. minutes of the public hearing, proposed code amendments. Motion to approve those minutes.
So moved.
Do I get a second?
Second?
Second by Commissioner Dant. Call the question. That moves forward by a vote of 5-0. And last, we have the minutes of the special call meeting agenda review work session from January 24th, 22, 1:30 p.m. meeting. Motion to approve.
So moved.
Second.
Second by Commissioner Hughes. Call the question. That moves forward by a vote of 5-0 on those minutes. With that, do I have a consensus to adjourn?
Yes.
Seeing no objections to that, this meeting is now adjourned. Thank you.